Yes. What is the issue? Everything is ready. It was fixed for today for disposal.
Yes, Lordship, he can.
Why was I not? Why did you make a mention yesterday? Have you
Lordship.
taken the consent of the other side?
Yes, Lordship.
Both are agreed.
Yes, Lordship.
Mr.
M. Lago,
You are making a mention of
respondent.
respondent.
Yes.
Mr. M. Lego, Leonard Counsel for the respondent, submits that on account of the arguing counsels not being in town, the matter be adjourned today. The prayer is not objected to by the learned counsel for the petitioners. Accordingly, registry to list these matters after 6 weeks on a date to be fixed by you.
Yes.
May I, Your Lordship? Lordship, I beg to mention item number 31. Here we have filed our counter affidavit. Your Lordship, I have taken concern from the petitioner, Your Lordship. Here, Your Lordship, is central government has not filed their affidavit, so 4 weeks may be granted, Your Lordship.
It's only for an enhancement of the compensation, right? Why keep it pending here? Let him go there. Let them go before the authority. They have been paid some compensation. They want an enhanced compensation. What is your stand now in the affidavit?
Actually, here, Lordship, Arish
Okay.
Navam AAG is appearing in
Okay,
this
okay,
matter.
okay. On the prayer made on behalf, you have taken the consent from the petitioners.
Yes, Your Lordship.
On the prayer made on behalf of the respondents number, state respondents,
4 and 6, Your Lordship.
respondent number 4 and 6, so and so, not objected to by the learned counsel for the petitioners. Registry to list these matters after 6 weeks on a date to be fixed by.
Obliged, Your Lordship.
Yes,
Item number 26. Affidavit reply has already been filed.
Huh?
So let
Call
the rule may be issued, madam.
Why?
Madam, the
Radiographer.
medical department.
Radiographer.
Yes, medical department they have not filed.
Forget it. Radiographer.
Yes,
You want parity with GNM nurse,
yes,
right?
Yes.
You are getting 5,000, 8,000 in the 5th CPC,
yeah.
diploma scale. Your entry qualification till date is only diploma.
No, we are class 12 first.
I know that.
Class 12 pass.
It's diploma. The minimum requisite qualification is diploma
Class
in
12 pass.
radiographer. Huh?
And class 10 diploma.
Diploma. Then GNM, it is graduate nurses, BSc nursing.
BSc nursing is later course, madam.
And
None.
what
Prior
happened
to
to
that,
your, the matter was to be placed before the anomaly committee. What happened?
Here, madam, I'm appearing for respond numbers 8, madam, or 9.
Who is appearing for the finance department?
I'm appearing, madam.
Yeah.
Yes, madam.
In your affidavit, you have taken a plea
Yes, madam.
that the matter is now being placed
Placed
before
before
the.
it.
What happened?
It's still
16,
pending.
8 years onwards, till now, alumni committee has not taken its call. Mr. Son, be here. Let the matter be taken. We'll see what the anomaly committee did.
But, my lord,
Huh?
it's still pending, my lord, according to my instruction.
Why so long? What is the big thing? Anomaly committees are to be done immediately.
That's true, my lord, but it has been.
And they have disputed that in
Yes,
their reply.
But my HLSC meeting was, pay anomalies was passed in 2023-24, my lord.
But
It
not
was
before
done.
that.
Not, my lord.
Why? Why so late?
But not
That should go together with the pay commission implementation.
And may I pray that, my lord, this matter will be taken up next week. My lord. In the meantime, I will get instruction, my lord.
Get your instructions.
Yes, ma'am.
On the prayer made on behalf of the parties, registry to list these matters again on Tuesday. So, in the meanwhile, the Learned Standing Council Finance Department shall receive instructions as to the consideration stated to have been to being made with regard to the claim of the petitioners herein for an enhancement in the scale of pay authorized to them by the anomaly committee constituted in the matter. We'll see.
as per the, my lord,
Mr. So, we have our limitations in this pay fixation matters. Let us see how we can help you.
obliged,
This is one way of doing it. Let us see.
obliged.
How can I pass an order mandamus saying that you should get this skill? There has to be something from the
It's
respondents.
only
also.
prayer only, my lord.
No, no.
Just prayer before this lordship.
I know that. but that for that prayer to be accepted, I will have to have something from them also.
Yes, sir.
So let me try. We'll try on Tuesday.
Yes, ma'am.
Madam, you get your instruction.
Okay. Your Lordship.
Item number, what was your item? 26, okay.
May I listen? I'd like to know, item number 33, on behalf of, O Modi. His instruct, let me take adjourn.
There is a provision for appeal. Why these revisions are being filed? You go for that appeal.
Lordship, he's at Fasigal, so he,
Fasigar,
yeah,
online. I came reading. You should have told me yesterday. From today onwards, I'll not read one brief also. Tell me. I'll come here, take one brief, sit here for the whole day looking at that brief. That's not good for the bar or the bench.
yes.
You can tell me that we are not doing the matter. What is it? There are enough matters I'll do. Inside also I have enough work. And Mr. Tabin and Mr. Tara, when there is a decision from the village, what do you call the village authority, after the 2021 that Civil Codes Act, will a revision be maintainable because they have a provision for appeal now? Will a revision be maintainable?
15.3.
15.3. Appeal.
Appeal is there.
Appeal only. I thank the Arunachal Bar because here I get exposure for civil and criminal matters, which unfortunately I did not have that side. And I thank this bar for that, for educating me.
Yeah.
So, 2 o'clock. Pasigat, he'll not reach by 2 o'clock.
I will call.
Okay, we'll not put you into trouble. On the prayer made on behalf of Mr. O. Modi, Learned Counsel for the petitioner, registered to list this matter again on Wednesday. But no adjournments, no further adjournments would be granted in the matter. Yes. Hmm.
I would like to mention item number 25. It is in order column, Your Lordship.
Hmm.
It is in orders column.
Hmm.
I was supposed to file rejoinder, Your Lordship.
Hmm.
The petitioner here, petitioner is belong to your, for.
What rejoinder? You were supposed to appear before the, give your statement. Shrayansh Jain. Which is the item?
25, Your Lordship.
25.
Yes, Your Lordship. It is a,
Okay.
LPC.
You be here. We'll put it up for admissions. You be here. We'll pass orders. I'll not dispose it of. Don't worry.
Yes, Your Lordship.
Hmm.
But I am extremely sorry.
Hmm. When Mr. Tara is sorry, then the court should be very cautious. What has happened?
Kindly allow me to move one urgent read petition.
Why should you be sorry? You should be happy that you are moving it. Happy in all respects. Yes, what is it?
After expulsion, then
Oh, what is it?
after expulsion, they are going to terminate.
Service matter.
No, sir, it's a constitutional matter.
No, what happened? What is the issue?
There was an appeal. The commission has given the decision that the ex parte stay order has been granted, and now they are
Commission by which commission?
election commission.
Hmm.
And then they are going to
Panchayat.
on the state of the
Panchayat matter. Panchayat.
municipal.
Municipal.
On the basis of that, they are going to disqualify us. That's the urgency. I don't know, but after this afternoon, the order might come out also. Just
Take it up.
thank you. Oh, what is it?
Your Lordship, I beg to mention item number 14. Since the leading counsel is out of station.
You were supposed to file a fresh settlement deed.
Yes.
Why?
Actually, I was told that he has already submitted the leave of letter of absence also.
What is his name?
Tigame.
There is an interim order here.
Yes.
Yes, what do you say?
Yes, Your Lordship, they were directed to file a fresh
Fresh deed
agreement,
settlement.
which has not been filed.
Not been filed. J. Doji.
Tigame.
Item number
14. It's there, but your lordship, it is not reflected, the
Okay,
name of the tea government. In the last occasion also, it was mentioned that it must be reflected.
and where are the other councils? J. Doji, R. Nazi, D. Yoka,
They all are abstaining,
all absent.
yes.
The responsibility is on you.
No, this
How long have you been in practice?
6,
6 years.
yes.
Hey, I'll do. 2 o'clock. You will argue today. You argue. I'll help you.
Lordship, this is not my matter actually.
Okay, we are appointing you amicus curiae in this matter. Amicus in the matter. Prepare. 2 o'clock. You should also understand.
Yes.
I prepared. So you
Yes.
should also prepare. Otherwise, it's not going to be beneficial. Prepare and come. Madam Ginny is also prepared. Right?
Yes.
Some difficulty will look.
Lordship, when in our part it was supposed to file a fresh agreement.
Huh.
Then
Long back.
long back, yes.
Those
That
days have gone.
that agreement was not materialized.
Materialized. Okay, fine. Then we will dismiss the petition, criminal petition.
Kindly more time may be given.
No. If the petitioners are willing to have a agreement executed, why should this court, let the trial take place?
Lordship,
Otherwise, if we start passing orders like this, the trial courts would be redundant.
no,
There
at
will be no work.
this juncture, your Lordship, we are tracing this victims' families.
You be here when the matter is called up. And even a criminal revision, I think, cannot be dismissed for default.
Default, Your Lordship.
So we can appoint amicus curiae and
Yes.
hear the matter.
Yes.
Much obliged.
Yes.
May I please, Lordship, I beg to mention item number 23.
Orders matter. Be here when the matter is called up.
Okay.
Any urgency? You have to go somewhere.
Actually, your Lordship, conducting counsel is out of station, so I'm
You are not in the matter. You are not in the matter.
No, I'm there.
You are there.
But I'm not well
You are
acquainted.
also, why are you not well acquainted? Now you will have to read the brief when the matter is called up. Read the brief and come.
Lordship, kindly matter me
No,
fix after 2 weeks.
you
2
read
weeks.
the brief and come. I assure you, I'll not dismiss the matter, but I'll hear you. Read the brief and which is the item?
23.
23. I'm making a note. You read the matter and tell me what the case is. We'll take it up today. You be here.
Okay.
But read the facts. Only the facts I want from you. Well, we have to come into. Facts के साथ नहीं है वहां पे नहीं करना. Okay, we'll pass it at 2 o'clock. 2 second. 2 बजे. 2 o'clock. All this to 1 to 5, 2 o'clock. Fine is there. Yes, who is appearing? Deposit made?
I beg your pardon.
Deposit, it's okay. Deposit made? Have you deposited? No,
Actually,
we are dismissing it.
actually, after this order was
We
passed,
can't help it, mister. You have been given a very long rope. We'll dismiss it. The present present petition has been, revision petition has been instituted, assailing an order dated 12/11/2024, passed by the session judge in IA criminal number 306/2024. Also, the respondent herein had instituted proceedings against the present petitioner. Why have we not deposited the money? After so much of leave given,
I have, last order was informed to the
petitioner, he is not interested.
on the,
Now he'll face the music. Once we dismiss this, he'll face the music.
but thereafter instruction was not given to.
Okay,
So I'll
fine.
leave to the wisdom of.
We'll record that, don't worry. Under section 138 of the NI Act, also, the learned CJM, Papum Pare, UPN, while judgment and order dated 23/3/2023 proceeded on consideration of the issues so arising therein to hold that the petitioner herein is guilty of the offence under section 138 of the NI Act and convicted and sentenced the petitioner to pay a fine of rupees 1 crore 18 lakhs, the words of the river, for the loss and damage sustained by the respondent herein due to non-payment of the check amount. It was further directed that the accused shall undergo simple imprisonment for 1 year in default of the payment of fine. It is seen that being aggrieved by the order judgment dated 23/3/2023, the petitioner herein had instituted criminal appeal number 02/2023. The appellate court wide order dated 11/8/2023 on the inability, on the default on the part of the appellant herein, of the petitioner herein to pay the amount so required to be paid by him, proceeded to institute an appeal being criminal appeal number 202/2023 before the court of the session judge UPA. The learned session judge, while order dated 3/5/2023, no, 26/6/2023, directed the petitioner herein to deposit 20% of the fine amount. However, the said amount not being so made, the appellate court had while order dated 4/8/2023, granted further 1 week time to the petitioner herein for depositing 20% of the fine amount. The matter was taken up on 11/8/2023, and on the said day, the appellant, being personally present before the court, expressed his inability to deposit the 20% of the fine awarded. Accordingly, the appellate court, while order dated 11/8/2023, proceeded to dismiss the said appeal. Being aggrieved, the petitioner herein had instituted criminal revision petition number 32/2023 before this court. This court, while order dated 27/6/2024, on consideration of the issues arising in the matter, was pleased to dispose of the criminal petition by interfering with the order passed by the order dated 11/8/2023, passed by the learned session judge UPI in criminal appeal number 02/2023, and remanded back the matter to the court of session judge UPI. In the said order, it was provided undertaking of the learned counsel was recorded that the petitioner herein be granted 3 months time to deposit the 20% of the awarded fine amount before the learned appellate court. Full stop. This court also in the said while permitting the petitioner to deposit the fine amount within a further period of 90 days from the date of passing of the said order dated 27/6/2024, further provided that in the event the petitioner herein failed to deposit the 20% of the fine amount awarded by the learned trial court, the learned appellate court shall be at liberty to pass necessary order as per law. So, thereafter, in terms of the direction passed by this court while order dated 27/6/2024, the appeal being criminal appeal number 02/2023 stood revived. So, where is this IA application in your record? Page
45.
So, the petitioner herein instituted IA number 306/2024 in criminal appeal number 02/2023, praying for grant of further time to the petitioner herein to deposit the remaining 20% of the fine amount as directed by this court. Full stop. As direct fine amount. Full stop. The said interlocutory application being IA criminal number 306/2024 was taken up for consideration by the learned appellate court and while order dated 12/11/2024 by recording the following submission. By order dated 12/11/2024, the following conclusions were so recorded. Full stop. Para 5 para 9 only. Full stop. But by recording the above conclusions, the learned appellate court proceeded to hold that the appeal, criminal appeal number 02/2023 could not be admitted for hearing and the same was disposed of along with the interlocutory application number 306/2024. So being agreed, the petitioner has instituted the present proceedings before this court. So on 4/12/2024, when the matter was taken up for consideration, the learned counsel for the petitioner had undertaken that the amount of 20% of the fine amount as directed by the appellate court would be deposited on or before 13/12/2024 and accordingly prayed that this court would be pleased to take up this matter today, that is on 13/12/2024. Also, in the said order dated 4/12/2024, it was also provided that in the event the amount is not so deposited before the next date of listing of the matter, further orders as may be called for in the matter on merits shall be passed by this court. Also, subpara. Mr. S. Chetri, learned counsel for the petitioner, today, when the matter was taken up for consideration today, has submitted that he had communicated to the petitioner about the directions passed by this court while the order dated 4/12/2024, as well as the undertaking so given in the matter on his behalf that the amount would be, that the fine amount, 20% of the fine amount would be deposited before 13/12/2024. Mr. Chetri has further submitted that in spite of repeated persuasions, the petitioner has not furnished any instruction to him in this connection and accordingly, he is handicapped in making his submissions in the matter. So, in view of the above position and considering the conduct of the petitioner as would be evident from the default committed by him, both with the directions passed by the appellate court in criminal appeal number 02/2023, as well as of the directions passed by this court while order dated 27/6/2024 in criminal revision petition number 32/2023. This court is of the considered view that the present criminal petition would not mandate a consideration on merit and accordingly the same stands dismissed. The order passed by the learned appellate court the order dated 12/11/2024 passed by the learned appellate court in IA criminal number 306/2024 in criminal appeal numbers 02/2023 disposing of the interlocutory application along with the appeal, said criminal appeal would not call for any interference. Accordingly, the present criminal revision petition stands dismissed. There is a limit. Yes,
My lord. My lord, this.
is this power of execution still with the deputy commissioner after the
Yes.
new, it's still with
Yes,
him?
Lordship.
Heard Mr. G. Taluk, learned counsel for the petitioner on Mr. Smith so-and-so, learned counsel. You are paying for all the, you are asking for response number one.
One only.
So, issue notice, returnable 4 weeks. Ms. So-and-so accepts notice on behalf of the respond number one. No formal notice is to be issued. However, requisite extra copies of the petition be served upon her. Petitioner to take steps for service of notice upon the petition. Respond number 2 by way of registered post with AD. Dusty also? No.
Both.
Both. And also by dusty mode routed through the registry of this court. In the on taking steps on taking steps by dusty mode, the petitioner shall file an affidavit to the effect before this court on the next date, before the next date of listing. Steps within 3 working days from today. Registry to list this matters after 4 weeks on a date to be fixed by.
Lordship, we in this matter with a alternate player as well, Lordship. Alternate
I
player.
will not pass that order without hearing the private respondent. There is a private respondent. I've seen that. Let the private respondent come, we'll dispose it out.
Because Lordship, if the an order is passed because
Can't help it because without hearing them, we don't know what exactly, we only know your story.
yes,
We'll also have to know the other story.
that is why you, Lordship, we are praying that the respondent number 1 may dispose of our representation.
No. You have come here, we'll decide.
Much.
Obliged.
Yes, ma'am.
Case diary may be called for, Lordship.
May please, my lord.
Where is the FIR?
Page 13, Lordship.
My lord. May I read?
Yes. Foundational facts are there. How long have you been in custody?
Till today, 15 days.
Only.
Yes.
The heard Mr.
El Kagum.
L. Taluk, learned counsel for the petitioner, also heard Ms. L. Hage, learned H. Lakshmi, learned counsel, learned additional public prosecutor, appearing for the state respondents. The present bail application has been instituted by the applicant praying for bail in connection with Itanagar Women Police Station case number 66/2024 under section 69/91 BNS 2023. The petitioner hearing was arrested on 28/11/2024 and presently he is in judicial custody. Also, issue notice, call for the case diary of the above mentioned police case. When
Next week also, case is allowed.
registered to list this matter on 17th.
Like,
Oh, nice.
17 crore, huh?
Marketing.
Hisam land. What do you mean by this word Hisam land?
Malabhisam is the particular area.
It's a name of an area.
Yes, name of that area which is developing and that has been now covered within the
But there are many proceedings pending.
many proceedings for pending. But despite of that, still, this time we recovered that there has been a which
6-5, but the subsequent Kebang decision
Mal.
is also under challenge before in a proceeding before this court.
despite of that, Malam,
No. You have now challenged 6-5, I suppose. Okay.
so Malam, finally,
We'll not pass an interim order. We'll issue a short notice. You get the copies served. Madam, you also have your instructions.
Yes, ma'am.
Thereafter, we'll consider. We'll make the interim order also returnable.
Mal.
Right?
Mal.
Heard Mr. C. Modi, learned counsel for the petitioner. Also heard Ms. You are appearing for?
One,
T1
three,
more?
1, 3, and 5.
For respondents number 1, 3, and 5.
My lord, I am appearing on behalf of the Kamdu, Standing Council of Land Management.
Which,
Content number 2,
Mr.
M. Ratan,
M. Ratan, learned standing counsel.
the Kamdu.
No, learned standing counsel, which land management. Land management department appears for respondent number 2 and 5.
No, only 2.
Only 2.
Only 2. So you are appearing for
1, 3, and 5.
Right? 1, 2, 3, 1 to 5. Full stop. Who is appearing for respondent number 4,
4 and 6.
6? Mr. Kato can appear.
Kato, yes.
He is here.
No.
Who is any CGC? Give me a name of one CGC, any CGC. Who is present today?
No one present. Yeah, earlier M. Kato used to appear this way.
Okay, you take steps. Push up. So, likhila na ito. Push up. Issue notice, returnable 3 weeks, 4 weeks. Push up.
Made my
Ms. So-and-so accepts notice on behalf of respondent number 1, 3, and 5, and Mr. So-and-so accepts notice on behalf of respondent number 2. Petition, full stop. No formal notice is to be issued. However, extra copies requisite, huh? Likhidi bhai Push up. Petitioner to take steps for service of notice upon respondent number 4 to 16 by way of registered post with AD. Full stop. Steps within 3 working days from today. Full stop. Also issue notice on the interim prayer, also returnable after 4 weeks. Full stop.
Can it be my lord 3 instead
You
of
will have
4?
to take registered post. It may take time. That's why I put it.
Of like.
Lordship,
My lord, I am appearing for. May I, Lordship? I'm
Mr.
on duty, you know.
Toto, nice to see you. That too
Yes,
online.
Your
You
Lordship.
should have been here.
Lordship,
May
Lordship.
Lordship, kindly pass over for some time, Lordship.
Toto is you are for whom?
Petitioner, Lordship, on behalf of
You are appearing for whom, Mr. Toto?
I'm appearing from respondent number 5. my lord.
Respond number 5.
Lordship,
Respond
kindly
number
have a
5
look
is
at the
that-
last.
Respond number
NHIDCL.
5 is NHIDCL.
Yes, my lord. And on the last day of the order, my lord, on 18/9.
You have filed an
2020,
affidavit also that you have made the deposits.
I made the deposit. In fact, my lord, kindly have a look at the 18/9 order of this honorable court.
18-9.
Yes. How I am in contempt, my lord, that has to be addressed by the petitioner. Because
Okay,
I am
fine.
the only the.
Yes. Who is appearing for the state respondents?
Is that state only, my lord? I'm only requiring authority. I already deposited the
Oh,
money.
we can see Mr. Dotto. That is the requirement of your impediment.
But
Yes.
how I am in contempt, my lord?
You're not in contempt. We'll hold that. Don't worry. Yes.
Therefore, my lord.
My lord, I am appearing for respondent number 1, that is land management.
Okay. Who is you have deposited the money with whom, Mr. Dotto?
I'm a respondent number 4, my lord.
Oh, who is respondent number 4?
It's a DC, my lord.
DC. Yes, who is appearing for the DC? Deputy
We
Commissioner.
already did with 10 lakh, 58 lakhs, 10 crores, 58 lakhs.
No, in this case, it is 3 crores something.
Yes.
Two cases, Lordship.
2 cases again.
Yes, Lordship.
Where is the other one?
No, here is Lordship.
1. 3 crores.
No, not only 3 crores, 7 crores over here.
Here also.
7 and 3. Yes, yes.
7
10.
crores, Lordship.
Yes, who is appearing for the Deputy Commissioner? Miss Sete,
I am not in this.
you're not.
No.
M. Ete is. You are appearing for the Deputy Commissioner?
No, my lord, I am for.
So we'll call the Deputy Commissioner now. Why is the amount not being paid? The money has been already deposited.
Yes, my lord. We have done our duty, my lord. Deputy Commissioner, my lord, why he is not paying, my lord? I am for.
There is nobody who is the Deputy Commissioner now.
Ugly, sir, my lord, he is.
He is not a party.
He is the party, my lord.
Sri Pagli Sora.
But my lord, this new incumbent is joined here, my lord.
Whoever has joined. Miss Ete, this is a contempt matter. Whoever is there, we are not worried. But the stand of the respondent number 5 is that the amount 7 crores and 3 crores have already been deposited with the
Deputy Commissioner.
Deputy Commissioner. Why is the money not being released to the petitioners? I want an instruction on that. Get that instruction. This money was deposited
On 16/6/2023, my lord.
16/6.
2023.
Until now, the money is not being, and the Deputy Commissioner is sitting tight. You have your instructions.
I may be exonerated, my lord.
This amount was deposited by check
Where from?
dated. It's 16/6. 2 checks.
Yes, my lord.
Yes,
Lordship.
have your instruction. Call him. Have you
I'll
answered?
get the instruction.
Today.
One last one.
Today.
Today.
2 o'clock.
Lordship.
And if there is a default on his part, tell him we are calling him.
Yes, Lordship.
My lord.
Where is this district? You know the district. You can take a copy. Or you can
Yes,
have
Anini.
this. Madam, you can have this.
Lordship.
You can have this affidavit, 9/12/2024. Mr. Counsel, you have the affidavit dated 9/12/2024.
Lordship, actually, I'm not in
Oh,
this
you
matter.
don't get that. You're not required. You're not required.
Lordship.
It's between me and you. This. Mr. Roda, you are on the safe
Yeah.
side. You have done you have complied with the orders. Let's see how we can get it cleared up.
May I appear on 2 o'clock, my lord?
2 o'clock.
My only submission, I may be exonerated, my lord.
You will be. We'll close the entire thing. Let the money be go. Let the money be released.
Lordship.
Now we will require your assistance as an amicus in the matter now.
Lordship, I'm so grateful, my lord.
2 o'clock, Mr. Roda.
Oh, my lord.
Is that it? Just get your instruction. What
Yes,
it is.
yes, Lordship.
Bless you.
Yes, who is appearing? Comment. Yes, madam. What is your submission?
Lordship, he was here. Lordship, the petitioner, Lordship, have
Come straight to page 70.
17, Lordship.
70. You got it? This is the penalty now. After appeal, this is what has been imposed upon him, right? He was dismissed. Reinstated.
Reinstated,
Ah.
Lordship, and then. brought
Suspension
90
period,
Yes.
suspension order is revoked. Suspension order is revoked.
Revoked.
Now you say period of suspension, intervening period of dismissal from service to till the date, proceed to the date of joining by so and so on his reinstatement in service, be treated as EOL on the principle of no work, no pay.
Lordship.
Where was his fault? Now that you have reinstated him and see further, but the period may be counted for the purpose of pensionary benefits. Now, if you hold it to be EOL, okay, fine, don't pay him any salaries. That's what I told the learned counsel for the petitioner.
Lordship.
Don't pay him any salaries. But that period, you will have to fix it notionally. He is not getting any benefit otherwise. You have reinstated him, you have removed the order.
That's true, Lordship.
So if you agree to that, we will dispose it off in that manner.
Otherwise, Lordship is,
We'll only say notionally you fix that period. The date he rejoined his services, from that day give him the areas. And accordingly, his pension and pensionary benefits will also be now recalculated. That's all. Release the areas within time frame.
Lordship. Otherwise, in our, Lordship, affidavit filed by number 5, Lordship.
Yes.
Here, annexer E17, they have walkout, Lordship. Page 17. By respondent number 5, Lordship. Lordship, this is from the, it's for the instruction of the Director of Audit.
Ma'am, this is not that because you have taken out that period away.
Yes. This order is of 24th November 2020.
So this period 6/11/93 to 17/11/2019, the
Yes.
whole period you have done away with. And what you have done is you have just Mr. Das.
Yes,
What do
Milord.
you have to say about this page 17 of the respondent number 5's affidavit?
Milord, what they have done is that they have reinstated me in service and fixed my pay as if I am a new recruit.
No,
And
no,
gave-
you come to page 17. Annexure E.
70.
17 of the affidavit filed by respondent number 5.
Milord, I'm extremely sorry. Somehow, Milord, it's not there in my.
I think you will have to collect that because they have done some calculations here. I also missed it out. I think
Yes.
you will have to go through it. Ask your counsel here to send a copy to you. We'll have
Yes.
it on Tuesday. Tuesday?
Yes, Milord. Fine.
Any outstation matters on Tuesday?
No, Milord. I'm here only, Milord. Fine, Milord.
On the prayer made on behalf of by the learned counsel for the parties, registry to list this matter again on Tuesday.
My Lord, may permit
You
me
just-
to come through remote VC.
No need. You can come by VC. We don't want you
Fine.
here.
My
Be
Lord.
there.
My Lord, can it be on 18, my Lord? If not inconvenient, my Lord.
18, 17, any problem?
Some matters here, my Lord. Back to
Because
back.
what is that? 18, 19, the 19, maybe this court is there. 20th, we don't know. So we have to pass an order. Okay, 18, we'll try. 18.
18, my Lord.
18.
18. Much obliged. Please, Your Lordship. This,
Madam, what is this with regard to, just give me an idea about 195 and 340.
Yes, Your Lord.
Is it the order of the court? Is it not itself something in writing? Whether that is not sufficient for institution of proceedings?
No, Your Lordship, as per 340, the complaint has to be given to the magistrate first class, Your Lordship, be it by the court or the officers of the court, Your Lordship. But it has to be in writing in a proper way of complaint and then given to the magistrate's court, Your Lordship.
Okay, so an order of the court by itself
So
cannot,
does- Yes,
it's a technicality.
yes. Preliminary inquiry as 354 can be reflected in the order
Order.
as given in this case, Your Lordship.
But-
However,
But for institution of a criminal proceeding, there has to be a debtor.
yes.
Yes, Mr. Singh.
Lordship, apart from that, Your Lordship, the entire trial is concluded and in the present case, the accused person has also been acquitted, Your Lordship.
You have been acquitted.
Lordship.
What is there?
Nothing is happened.
You witdraw it.
No,
Mr.
but the thing is that, Lordship, the fact is that the FIR is there. The still FIR is existing, Your
You
Lordship.
get that order of the learned trial court. No, you file it by way of an affidavit.
That I will do.
Mr. Singh, learned counsel for the petitioner submits that certain developments have taken place in the matter. And accordingly, he prays that he be granted liberty to file an affidavit in the additional affidavit in the matter. Prayer granted, raised a petitioner to file the additional affidavit. To facilitate filing of such additional affidavit by the petitioner, raised to list this matter again after 4 weeks on a date to be fixed by.
Lordship, there was an interim order.
Interim order passed earlier to continue till the next date of listing. That now has become, what is,
Because
anyway,
this is a fresh initiative.
fine. Or that main case is over, the other one is pending.
Yes.
We'll caution, we'll caution. Now we have understood, we'll caution. Yes. Yes, Mr. Sunil.
My lord, I am very sorry. Last occasion I could not.
Come on, Mr. Sunil. I forgot it. We can have some fun sometime. Huh? Not at the cost of anyone, but just for the lightening the atmosphere. And expect that daily from this court. Yes, now tell me how this case is maintained.
My lord, this is the order.
You are asking me to exercise my superintendent's power.
Yes.
Do I have a superintendent's power? This court has a superintendent's power with the State
Commission.
Information Commission.
Yes.
Do you know there is a rule we have? We have a rule to that effect. 396. Hope I'm not wrong. I'm not wrong. Read this rule. I can understand a repetition under 226, but and read 2271.
Yes, my lord. My lord, this is.
I understand. Maybe a mistake, but if you want to elaborate on it, do it. I told you this. Don't
Yes.
succumb to them.
Yes.
If you want to prepare and come back. Because there is an interim order operating in your favor. If I say today, no, it's not maintainable, it's the end of the matter for you. Till you institute a writ petition against this. which I'll give you a liberty. But why don't you prepare? Try to convince this court that this is maintainable. I've shown you the parameters.
Except the tribunal, the
It's not that. We don't have, it's a creator of the creation of a statute. It has some civil powers also, but it does not come within our superintendent's power. We don't exercise superintendence there. We cannot interfere or we cannot call for the records of information commission. But the tribunals that are mentioned therein, we can call for those records. We can sumoto call for those records. And the Supreme Court decisions are there where there is administrative power under 227. It also extends to the judicial side. We have judicial power also. So a certiorari can be issued. So, Mr. Sunil, prepare. There is no rush here. You prepare and come back. Okay?
my lord, I will submit few things, then I will prepare in next.
Yeah.
My lord, in the case of against the order of the State Consumer Redressal Commission, that under 227 it was maintainable, and against the order of the National Consumer District Redressal Commission, in one of the cases, the Honorable Supreme Court has stated that High Court under 227 it can be,
Observable.
yes.
Show me those judgments.
Now I don't have, because this
Get
matter
those.
was, because one of the appeal was pending before the State Consumer Redressal Forum. Then I have filed a civil revision petition under 227 before this honorable court.
And the Supreme Court has also upheld that.
This court dismissed the petition by saying that there is a since it is pending before the National Commission, State Commission, you appear before the appropriate forum. Thereafter that matter, I appear before the State National Consumer Redressal Commission. There the honorable forum, it was observed that it can be, High Court has the
Honorable National Commission does not have the power. Supreme Court, I can understand.
Yes.
The order is by the National Commission or by the Supreme Court?
That order is passed by the National Supreme Court.
Supreme Court?
Yes.
Just give me that. I'll change my view.
Cite that Supreme Court, some case law was cited.
Give me. Why didn't you carry it? You knew. Last time I told you. You should have carried it. We could have deliberated on the issue. See, my view is tentative. I want an answer from you.
My lord, then where will go?
226. 226 power is always there. So you give me that judgment. If I may be wrong, so I'll correct myself. Give me that judgment.
My lord, give me 2 days. I'll print out all the cases.
Okay. On the prayer made on behalf by Mr. T. Sunil, learned counsel for the petitioner, not objected to by N. Duncan, learned counsel for appearing for the respondents. Raised it to list these matters again on
18, my lord. Since there is an interim order operating against me.
17,
17, I have the difficulty.
16, Monday. Monday,
18.
18.
And my lord, if in case, if I do not succeed, I will come under 226.
You will have to. See,
But anyway, I'll try to.
see, when I was going through it, I developed an idea that this is not meant. I disclosed it to you. Now it's for you to satisfy me that, sir, see, this view is not correct. This is the correct view. Enough. We are not here to impose our view. We are here to execute the law only. Show me the correct position, I'll come with you. I have my doubts. Otherwise, this petition would have gone much before. It would not have survived so long. I have my doubts. That's why I am restraining myself.
Otherwise, my lord, in number of cases, in such matters, the Supreme Court has said that when there is no provision for appeal or revision, in such a case, unless it occasions in gross injustice,
if, because in commission, in RTI commission matters also, there is no provision for appeal. So the intention of the legislature is that there should be finality to this. So that is why the superintendent's powers are usually not,
2 to 6 vote.
yes, 2 to
It-
6.
You also examine the matter, madam is correct. Finality of a statute. Once a statute has attained finality, that order, a person cannot be left remediless. He will have to have some remedy. What is that remedy? So remedy is 2 to 6.
In fact, I would prefer, instead of waiting so much time, if you could withdraw and file again. I mean,
No, ma'am,
What?
no. You guys, let him prepare. I want him to prepare. That's all.
oblige.
Yes.
Yes.
Why this was not done? This order was passed in 11/9.
Yes.
This court was naturally not satisfied with the. So why the thing was not filed?
There was actually logistic problem, my lord. Since the deceased family, they could not be located.
They could not be located.
Yes,
Then
because-
how can we now come in?
No, that's why,
You withdraw it. What do you call that? You face the trial.
yes, that's why we are asking, we are praying for more time. So that-
Why? From September,
Yes.
October. This is the month after 2 months.
Yes, yes.
Around 3-4 months you got time. You couldn't do nothing. What will you do now?
My lord, we have to see the circumstances also. The disease was a labor. The complainant was.
Mr. Counsel, you have not projected this case in that line. You have projected this case on the basis of a settlement.
Yes.
We'll not go beyond that.
Yes, since that earlier settlement was rejected, so we were asked to,
You undertook.
yes.
You
So-
undertook. You are Mr. Game.
No,
Oh. Mr. Game undertook that he will file a fresh deed of settlement.
yes, my lord.
So,
So to drop a new settlement, we had.
so what we do is we vacate the interim order and keep the matter pending.
My lord, more time may be given so that we can locate the
How
family.
much more time you want?
4 weeks.
Give me a date. See the month of May, that will be January,
January, in the first week of February.
first week of, we'll give you in last week of December, next year, 2025.
My lord, there will be a festive.
Your name,
M. Ranka.
M.
M. Ranka.
M. Ranta, Lana
Yes.
Counsel, appearing on behalf of Mr. You're not in the case,
No,
Mr. T. Game
he coming.
submits that the petitioner be given, the petitioners be given for time till (16) 2025 to bring on record the fresh deed of settlement between the petitioner, between the petitioners herein as undertaken before this court and reflected in the order dated 11/9/2024. So it is provided that in the event no such undertaking or no such compromise deed, settlement, deed of settlement, no such deed of settlement is placed on record before the next date of listing. So, comma, further orders as may be called for, including vacation of the interim directions, shall be considered by this court. So, list this matter again on 17/1/2025.
17/1.
1/2025. 15 question, 16 question, 16 question. 17 we listed, and if you don't file it by, okay, put it on 20th. 21/2025. If you don't file it by 16th, next date we are going to vacate it. Okay? Done.
Deeply.
Oblige.
Are you getting your provisional pension? Huh? Not giving?
Yes, no.
Yes. Why? There is an order?
Yes, my lord, there is order. For that,
Then,
my lord, I need to think why,
No.
my lord.
no. Who is the authority who is violating this order? We'll drop a suo motu contempt now. You don't settle his pension, and we have directed that you should be paying him his provisional
Yes,
pension.
my lord.
Why it is not being done?
Not sure, my lord. We are
Not sure.
my lord.
Be sure and come back by. Otherwise, I'm going to call this officer today.
My
We are
lord,
trying suo motu contempt.
humble submission, my lord. We are. Yes, I know the view of this honorable court about the pension, my lord. I also seriously pursuing the matter, my lord. Now,
I don't want the finalization. I want the provisional thing.
yes, my lord. Provisional, we are payment. How that was discontinued, my lord.
Provisional lordship after 6 months lordship, and after this order lordship, provisional pension is not continued lordship.
Not continuing.
Yes, lordship.
Fine, that is enough. 2 o'clock, I want the instruction by Monday, continuation order. Tell your officer, if he can't do it, tell me. We'll do the needful.
My lord. Obviously.
This is not done.
Yes.
When we have passed an order, you go upon appeal, file review. When the order is existing, how can you blatantly violate that?
Yes, ma'am.
You can't. So, Mr. Prami, get your instructions. We will have it at 2 p.m.
Obviously.
Yes. Where is the seal cover in the sealed cover?
Your lordship, they have sent it instruction, your lordship.
What is this instruction?
They are
That
saying,
means nothing is there.
oh, it's under seal cover, your lordship.
Where? Where is that seal cover? Oh, this is the seal cover.
No, they have only sent the minutes of the meeting, your lordship. They are saying that they are not going to send a seal cover.
Why?
I don't know, they are saying that
With reference, I'm directed that person is not aware of the recommendation made by the DPC because same in seal cover. It is to be mentioned that seal covers are coming. Is there a stay order in the appeal?
No.
your lordship.
In fact, even notice has not been issued.
Madam, you're in trouble. Who is this officer who has sent this instruction?
Personally, your lordship.
Ask him to come. 2 o'clock. We'll talk to him.
Here, your lordship, in Arish Nabam is appearing in this matter, so he's not present today.
We can't help it. What is this instruction?
Yes.
Who is he to withhold the information? Is it national secrets? Then get your seal cover thing by 2 o'clock, or I am calling him at 4:30 today. I'll sit here if required till 8 o'clock, no problem. But I'll have him here today. Get the thing here, everything. What we have said, ask them to comply with that. This is not done, madam. You are an officer of the court first. Impress upon them. If they can't give it,
Yes, sir.
ask him to file an affidavit by 2 o'clock. Why he can't give it?
We have asked your lordship. They were saying that they won't give your lordship.
They don't give.
Yes,
Ask him
directly said to me.
ask him to come here at 2 o'clock and I tell that to this court with the law, with the provision of law. Ask him to come and tell me. 2 o'clock. Okay. If he gives it, fine, or ask him to come. Whoever the officer is, competent authority, he'll be here at 2 o'clock. Inform.
Okay, your lordship.
And if he doesn't come, I'll have the police arrest him and brought him here. I'll go to that extent. Don't worry. Orders of this court should not be taken in this light manner, casual manner. Do that.
Okay, your lordship.
You just impress upon them. Who is there for the petitioner? After your affidavit, maybe he has lost interest.
Yes, my lord. But this.
Lampu, where is Mr. Lampu? Lampu is normally here.
Yes. But this-
Okay, we'll take it up after some time.
Oh.
After your affidavit, nothing is there.
Yes, my lord. Problem.
Hmm. Call after the list is over. Yes, Mr. Singh.
My lord, in this case, they're seeking anticipatory bail application. However, my lord, with all fairness, my very limited understanding of law, this FIR itself is not maintainable. There cannot be two FIRs for the same set of
Same
facts.
thing. But we'll not go into that because they are not
Yes.
under challenge. We'll only allow them to go on bail. Heard Mr. Sansal on counsel for the petitioner, also heard Mr. P. Talo, learned counsel for the petitioner. and
J.
Mr.
Seringman.
J. Sering, London. You are for as a
SIT, special PP SIT.
special public
Prosecutor,
prosecutor, SIT. So the present application praying for him pre-arrest bail has been so. At the outset, it is to be noted that the present application is being considered under section, what is the 520 anticipatory bail section?
482.
No. This is under the code, new
482.
482. Under 482 of the BNS NSS 2023. Subpara. The present application praying for pre-arrest bail has been so instituted in connection with Crime Branch Police Station case number 13/2021 under section 153-1/500/505/506/506/34 of the Indian Penal Code 1860. Full stop.
Next one.
The said case was so registered basing on an FIR submitted by one Nabam Dodum, President ANSU on, what is the date of this FIR?
26/11/2021.
26/11/2021. So it is found that on receipt of said FIR, an inquiry was carried out, and basing on the said inquiry, the above noted crime branch case came to be so instituted. So it is available. It is from the records of the present bail application. It is seen that basing on the same allegation, another FIR was so instituted before the
Not looking for
North Lakhimpur Police Station, which was so registered as North Lakhimpur Police Station case number 1264/2021 under section 153A/150/500/505/506/34 IPC. Also, it is submitted at the bar that the offense involved in both the cases are one and the same. Also, in view of the above position, this court is of the considered view that the petitioner herein is entitled to be extended with the privilege of pre-arrest bail, and accordingly, in the event of his arrest in connection with crime branch case number so and so under section so and so, he shall be released on bail of an amount of ₹5,000 with one local surety to the satisfaction of the arresting authority. Full stop. Arresting authority, subject to the following condition. 1, he shall cooperate with the investigation of the case and shall appear before the investigating officer as and when called for.
Lordship,
With the above observation,
a small prayer, Lordship. They are natives of Assam, Lordship. They may not have
local surety, like a one surety of life.
Much of it.
Disposal, bail application disposal. Next one also same. 19 also same. Same order. Same cases both.
Lordship.
Disposed of.
May I please, your lordship?
Yes.
Lordship. This
Yes,
case,
Mr.
lordship. CD was called for, your lordship.
CD has come.
Yes.
What is it?
In fact, your lordship, the petitioner has already appeared before the investigating
Waiting for
officer.
police.
His statement has been recorded, your lordship.
Mr. Ginny, you are appearing for whom?
Lordship,
In this matter or some other matter?
Lordship, here in this matter, I was appearing, Lordship.
For?
For the applicant, Lordship.
Okay, along with Mr. Bhattakur. Both are together.
Lordship,
No,
we are
no,
together. Maybe he's in another matter, or if he's in this matter, I don't know.
You are
Item,
appear-
I am appearing in item number 20, Your Lordship.
Oh, you are for 21. Okay, okay, fine, fine. Yes,
Yes,
anything?
Your Lordship, yes, Your Lordship. Your Lordship, though the applicant's name is not in the FIR, it was only through the his account details as well as the statement of the other accused that his name has been reflected, Your Lordship. His involvement is very clear. The other two person, they have personated as an executive member of that particular council, Your Lordship, corporation, Your Lordship. However, he being an executive member has made a link between these two named accused in the FIR, Your Lordship. There is also, though he has, after the interim, though he has denied his acknowledging that he knows Kuldeep Saxena, his CDR reveals that he has called 35 times to the alleged accused, Your Lordship.
Okay.
Also, out of the 5 crore as an advance processing fee, Your Lordship, 1 crore was deposited in his account, which has been revealed through the bank statement, Your Lordship. Also, though he has stated that he has another office in Guwahati, the statement of the corporation, Your Lordship, he has also sought reply, Your Lordship. They have clearly stated that he does not have any other separate office, Your Lordship.
This is the only office in the
Yes.
principal area.
Yes, Your Lordship. Also, Your Lordship, he has withdrawn 5 lakhs from the account of one of the accused, which has also
Yes,
been revealed.
Mr. Bhattakur.
Lordship, may I
There is
submit? Your
enough
Lordship?
material against you.
No, no, Your Lordship will kindly see 2 or 3 things, Your Lordship. First of all, Your Lordship, there is a, Your Lordship, in the FIR itself, I was personally not
Fine,
named.
not there.
No, no,
But
Your
the
Lordship.
thing is that CDR call records plus
Lordship.
the transactions that have been involved is
Lordship.
been done by you and in your bank account.
Lordship, Your Lordship, that Your Lordship, I am not privy to that since Your Lordship, this is based with the statement of the
I disclose that.
Lordship. Now, Your Lordship, there are 2 things. Your Lordship. First of all, if Your Lordships go through the entire sections, Your Lordship will find that all the sections are, Your Lordship, up to 7 years, Your Lordship. Now, going by the dictum of the Honorable Apex Court, Your Lordship, that it is the
No, I'm not on that. I'm not on that. I'm not on that. If you are not cooperating with the, just merely giving a statement will not do.
No,
if you
I
are not cooperating,
no, Your Lordship.
he is not cooperating, that means.
No,
No.
no,
No, Your
If he
Lordship.
is not cooperating, then what?
No, Your Lordship will kindly.
I give you one more opportunity. I'll give you one more opportunity. Appear again.
Lordship.
Disclose what is there completely.
Lordship,
Make
I will
fair
disclose
disclosure.
only.
Satisfy the authorities. We will give you bail.
Lordship will kindly hear me, Your Lordship, for a moment. I will do that. Your
Another
Lordship.
objection also put by the IO was that since he is the executive member, Your Lordship, the other accused has revealed names and bigger names in the corporation itself, Your Lordship. Now, yes, now and therefore his interrogation was very much necessary because he being the presently a member of these
Body.
corporation, yes.
He'll appear before you again. You appear, then we will see.
Lordship.
Heard Mr. S. Bhattakur, learned counsel for the applicant, and also Ms. Jenny, learned additional public prosecutor for the state respondent. Ms. Jenny has placed before this court
CBI.
the case diary, so received by her in the matter. From the case diary, it is revealed that the petitioner hearing had approached before the IO and gave his statement. However, there is a note from the IO.
Yes.
However, the note of the IO reply reveals that the petitioner was not cooperative in making his statements, and in view of the interim protection granted by this court, he was evading to answer questions so put to him.
Yes.
It is further seen from the case diary that there is enough material involving the petition applicant hearing with the offense alleged. Also, in view of the above, this court is of the considered view that the applicant be directed to appear once again before the investigating officer on when?
On 15th, Your Lordship.
Huh?
On 15th,
15, no? Give some time.
18th, Your Lordship.
18, on 18/12/2024.
Can it be after 20 euros?
Why?
No, Your Lordship, there is a problem. The problem is in the sense that, Your Lordship, there are in fact large number of cases filed in regard to Motok Autonomous Council, Your Lordship. There is a group, Your Lordship, racket going on. And
No,
CI
you know, I want the applicant to appear before the police
No, no,
on
I will.
18th. Any problem on 18th?
No, that's why, Your Lordship, after 20, I am submitting, Your Lordship. Any date after 20, Your Lordship.
Okay.
Now,
23rd.
why it is become important, Your Lordship? In fact, Your Lordship, documents they have sought from me, all these documents were seized by CID, Your Lordship, in Assam, Your Lordship. Because in Assam.
He is involved in
No,
a
Your Lord-
more
no,
better, larger scale, I suppose.
No, Your Lordship. In CID cases, we are not being called, Your Lordship. Only our documents are seized, Your Lordship, from us, Your Lordship.
Okay, on 23.
Lordship.
Your Lordship, if I may pray, Your Lordship, if it's on 22, his appearance, and if the matter is on 24, but otherwise because he's on interim, Your Lordship, then
Okay.
thereafter we goes
On
on.
2021, we will say.
Lordship.
On 21. On 21/12/2024. Also, the 21/20. Also, it is provided that the applicant shall fully cooperate with the IO in the matter and make fully cooperate with the IO in the matter. Also, list this matter again on 23/12/2024.
Lordship, on from 22nd, I will not be available, Your Lordship.
You
Can
will
it
have
be
to
in the-
because say 24th is the last day working here.
Lordship, I
Then
will
you
be.
appear before you appear earlier. We'll have it before 20th.
Lordship.
Then you have appear on 18th. We'll have it on 20th. Right?
Lordship.
Right? Appear 18 को idea. Our case to listing go 20th. Okay, sir? Okay. Interim order passed earlier to continue till the next date of this.
Your Lordship is fixing the matter on
20th.
20.
20. He'll appear on 18th.
Saturday, Your Lordship.
No,
Oh.
Friday. Friday.
20th is the
Yes,
Friday. Last
Friday,
working day.
Friday. Last working day. Here, last working day is 24th.
Lordship.
Deeply.
No. Yes, who is appearing? Has he appeared before
Yes,
the?
Lordship.
Huh?
He said, recorded his statement also. Lordship.
Then? Yes, Mr. Pincha, you are appearing for?
BC through BC.
Lordship, I am appearing.
Appearing through BC.
Lordship.
Sydney is here.
Yes. Two occasions, Lordship, I
What
have
is it?
already appeared, Lordship. 9th,
What is
as
it?
per, Lordship, as per direction, Lordship. 9th, I have appeared. 10th, I have appeared, Lordship. I have executed the bail bond amount also, Lordship. I'm operating with the
Any
investigation.
note from the IO? No.
Lordship, no, Lordship. The investigation is pending for recording of statement of the few relevant witnesses. That is all.
That's all.
Yes.
What is it? He has given, we'll let him go. So, heard Mr. J. Jini, learned counsel for the petitioner, also heard Ms. L. Hage, learned additional public prosecutor appearing for the state. Also, in terms of the liberty as granted by this court, while order dated 4/12/2024, the petitioner has appeared before the IO on 9/12/2024 and 10/12/2024, and his statements have been so recorded. Also, in the above view of the matter, and the petitioner not having violated the conditions so imposed by this court, while granting interim pre-arrest bail, while order dated 4/12/2024, this court is of the considered view on perusal of the case diary that further custodial interrogation of the petitioner in the matter would not be called for, and accordingly, the interim pre-arrest bail passed by this court, while order dated 4/12/2024 is made absolute, subject to the following conditions. 1. The petitioner shall continue to cooperate with the investigating officer and shall appear before the investigating officer as and when called for. 1. Two, 3. 3 to Khaliara change Koidiva, that the petitioner shall not leave the jurisdiction of the Itanagar shall not leave the jurisdiction of the CJM Itanagar without
CGM UPL Lordship,
CJM UPL without prior permission
from the court Lordship.
from the
Consent.
Jurisdiction shall not leave Itanagar without prior permission from the learned CJM UPL
And he should not,
during the investigation period.
should not induce any.
That we have given.
Lordship.
1 to Dilu, 3 to Dilu, 2 to Yapai Tegimo.
Obliged Lordship.
Disposed of. Wait.
Mr. Lampung is not here. Well, what I pray, my lord,
2 o'clock. If it doesn't come, we'll dismiss it for now. Mr. J. Ginny is the legal aid counsel, but his name has not been shown, I suppose. It's shown. Shown. Okay. Who is there for the applicant? Appellant?
Amicus Curie Minky Boje.
She is not here.
He is also not here.
The learned amicus curiae appointed for the petitioner, as
Pepper-
well as
You're also sorry for interruption. Paperwork's already served all of to all of us.
admission,
It may be fixed for hearing.
admission hearing.
Yes.
Nothing is there. What is there? Service upon all the parties are represented. Accordingly, raised it to this matter for it has not been admitted. I say. Has not been admitted. Raised it to this matters for admission after 2 weeks on a date to be fixed by.
Obliged.
Inform Mr. Boye that this matter would be taken up. Yes.
Lordship, this is an application under section 482 CRPC, passing of the FIR dated 21/03/2023.
What is the offense?
Lordship, offense is that I have illegally trespassed into their land and demolished their private property, cutting art and using folk land, causing heavy loss to the property.
Then what happened?
Lordship, I did not demolish any construction work. Your Honor, kindly come to the page 22 FIR.
No, I've seen it. I can go ahead. Then what happened? Then what is your legal ground? Who are you? Who are you?
I'm for I'm petitioner.
No. Who is the petitioner? What does he do? Okay. Next time, be more prepared. Seen the office note dated 9/12/2024. Service report upon the respond number 2 is awaited. So accordingly, raised it to list this matter again after 3 weeks. On a date to be fixed by it. So on the next date of listing, a note be put up with regard to the status of service of notice upon the respond number 2. So next time, you will have to be more Yes, Mr. Permit.
Mr. Mayor, as part of office note, my lord, service to respondent number 2 has been served. my lord. May I pray, my lord, this be listed in admission column and next statement.
Seen the office note dated 21/10/2024. Service upon the respondent number 2 has been held to be complete. Accordingly, registry to list these matters for admission after 4 weeks on a date 2 weeks by
Interim, my lord, edit.
entry order passed earlier to continue till the next date of list.
Obviously. Mayor, Lordship, I was supposed to file rejoinder in this petition.
Hmm.
However, the petitioner belongs to a remote area.
Okay.
So therefore, it is very hard for me to get.
Parties are represented, all the parties are represented.
Yes, ma'am.
Who is appearing for respondent number 4?
For
Gumi,
me.
you are appearing for respondent number 4. 3 to madam. You are for 1, 2.
1 and 2, madam.
1 and 2.
Yes.
So, heard the Lana Council for the parties. So, all the respondents seen that all the respondents are represented. Full stop. Accordingly, service complete. Registry to list this matter again for admissions after 3 weeks on a date 2 weeks by.
Your Lordship, I'm allowed to file rejoinder.
In the meantime, the petitioner is at liberty to bring on record his rejoinder to the affidavit filed by the affidavit respondents.
Yes. Highly available.
First of all, Lordship, interlocutory application IN number 73 for
It seems the council.
condemnation of delay.
They have not even filed a objection. Why? Time was given to them.
In fact, your lordship,
Criminal
if I may
petition
just surprise your lordship, 27 is also arising from the same case, your lordship.
Same matter. Same
This during the
Conducted-
pendency of 27, they have come challenging another order of the trial court, which was passed way before the order was passed in item number 27, and therefore, even otherwise, also in 27, your lordship, the trial has been stayed, your lordship. And subsequently, 28 during the pendency was filed, and therefore there was an objection for.
So what 20, if a decision is there in 28, it will cover 27 also.
27, both the matters. Yes.
Connected matter.
28, where is
Because
the FIR?
27,
Same FIR.
20, give me 28.
27 and 28.
31.
This is
Same FIR.
same FIR.
same FIR.
Where is the FIR?
Out of same FIR.
Your lordship, just a small appraisal, your lordship. Mr.
Taba, Teto Taba.
T. Taba is the petitioner in item number 28 and Learned Council.
Okay, we'll have it then after vacations. So, third day, counsel for the petitioner in applicant.
Can Lordship.
No.
Condonation, Lordship.
Condonation, you are there for the condonation.
Condon, Lordship. There is a, in the criminal petition number, revision petition number 10, there is a condonation. That may be condon, Lordship.
No, they have not filed, let them come. Who is there for the respondent?
They are always seeking time. Today, they.
No, 28 is there, that will do.
Yes.
That is the, no prejudice is caused to you. The trial is stalled. So,
Actually, I'm aggrieved with this stoppage of trial.
I know that. You are the lady, you are the person who had
I'm
instigated.
the victim.
I know that. Oh, that's right. Okay, we'll consider.
This may be condoned.
Show me your FIR.
In the criminal revision petition number, page number 69, FIR. Page number 69 of this criminal revision petition number 10. It is item number 27.
page number 69, FIR. This is very complicated one, Lordship. The dispute is with regard to consent. They are saying there was a consent. Promise to marry. It was the issue here.
See,
After cohabitation with that accused person, and it is the second person, his wife, Bisalpa Naham, in
least certainly better. At the learning council for the parties in IMMR, na 27 IA 70 criminal 73 2024. So, the learned counsel for the petitioner is not present on call. So, petitioner, you are also heard the learned counsel for the petitioner and Ms. T. G. learned counsel, additional public prosecutor. Registry to list this matters again after registry to list this matters again on in the second week of January for consideration. For the January. So in the meantime, the opposite party, IMA Ligran, I shall be at liberty to bring on record objections to the prayer for delay condonation. Okay, and if you don't file it, this you have taken much time.
In your lordship, I filed a reply.
Filed?
Yes.
When?
his filing.
Yesterday.
Yesterday. Okay, cut it. Mr. T. Riba, learned counsel appearing for the opposite party petitioner has submitted that the objections with regard to the prayer for delay condonation as made in the present interlocutory application has been already filed. Full stop. IA criminal 73/2024. Full stop. Accordingly, the registry to list this matters again on 8/1/2025 along with the copy of the objection so filed by the opposite party petitioner.
Yeah, Lordship, in this after 10. In this
10 after
yes,
10.
after 10.
15.
15, maybe 15.
15 one, huh? Done.
I can in both the case. I can
27, 28.
28.
28 खाली लिखा दीजिए along with कर दीजिएगा. Yes.
Yeah, please.
You were not here. There was another matter.
Yes, my lord.
You were said to be somewhere in Pasikat. You are not in a position to come.
Due to miscommunication, they have.
I can't see you. We'll take up that matter then. Which is that case?
Well, item number 33.
33? Okay. 33 call करिएगा. अभी नहीं. Serially. Otherwise, I will not see you in this case today because I can't see you. I have already passed an order. You are not here. So how can I see you on the same day? Why did your junior colleague make that prayer? That you are in Pasigar, you are not in a position to come?
My lord, actually, I engaged someone to adjourn the matter, but again engaged another one. So this is the problem.
Too many cooks spoil the broth. Okay, fine.
Lord, this is a
Robbery.
yes, madam.
Yes, what do you say about robbery? 392.
My lord, this actually, my lord, this 392 is not applicable in this case. 379 is applicable. My lord, moreover, the parties amicably settled the matter.
Yes. So, what do you say?
Yes, I've gone through the petitions. They have
Let them live peacefully.
resolved the matter. Yes. They have
Last 2 days I have not been able to quash anything, so this I am quashing.
because here
You see me, there is something material, tell me.
something metal is that their mobile handset was snatched from the wife of the
That has been returned.
returned and recovered.
And the money, they say there was no money. But they have now mutually agreed to resolve the issues. And they have said that this was because of a misunderstanding, this had all happened.
And they.
Does this man have any past antecedent, criminal antecedent? This petitioner, number 3.
No, in my knowledge, there is no any criminal antecedent.
Dagang Mada had no past criminal. He's also a chairman of some body.
Yes.
Okay. Cost.
Obliged.
Dispose of. मुझे दे दो. Yes.
Madam, for the petition and item number 30. Madam, on the last occasion.
Yes, you are ready for hearing?
Madam, on the last occasion, your lordship directed the my
They have filed, and I had directed you to file a reply, rejoinder.
Yes, Madam. By
So
6th
rejoinders
by-
have not come. We will proceed with this.
Madam, may I? Madam, when Madam they have served us, Madam, that is the Madam. And yesterday, Madam, afternoon, I have got the copy because Madam, they have been affirmed this.
Why was it served yesterday afternoon?
It's
Yesterday,
affirmed on
yes.
Madam yesterday.
When did you file this affidavit?
Actually, we filed yesterday only.
Why?
Actually, there was some document which need to be annexed. So,
Mr. Counsel, after the materials that have been brought on record now, we find it difficult.
Malad, that is the new thing they have brought Malad, and Malad, I will show to your lordship Malad, after my filing my rejoinder, I will show to your lordships. There is a Malad doctrine of non-traverse Malad. They have not traversed my Malad.
Forget the non-traverse. This is just a preliminary affidavit bringing on record your conduct.
Another thing, Malad, may I? Malad, I will show to your lordship.
These are commercial. These are
absolutely commercial.
Which
Malad,
which would have to go to the root of it. You participate in the.
I am bowed down to your lordship. But Malad, one thing your lordship has to see, Malad, there is difference between doctrine of suspicion and Malad, the Malad reasons to believe.
Mr. Counsel, those will come subsequently. Today, though that stage has not arrived.
Malad,
they have brought material wherein the
may
main allegation is that fraudulent activities towards input tax credit is being done by you and your organization, and
is not the allegation.
you don't even have a company.
Malad, that is not the allegation.
You file your rejoinder.
Malad, I will file
tomorrow,
Monday. Malad, yesterday evening, Malad, at least Malad 7 days. Malad, they have Malad 1.5 month Malad to Malad file and this opposition Malad. At least 7 days, Malad. At least 7 days. And Malad, my difficulty is Malad on 17th Malad date is fixed on the Malad in the trial court Malad.
Can't help it. Mr. Debashish Ghosh.
Yes,
Mr. Tanya, learned counsel appearing for the respondent has submitted that the affidavit on behalf of the set of the respondents represented by him was so filed on 12 December 2024, and he seeks apology for the delay so occasioning in the matter. Mr. D. Ghosh, learned counsel appearing for the petitioner, has submitted that the copy of the said affidavit was received only yesterday afternoon by him. Accordingly, he prays that he be granted 10 days time to file his rejoinder in the matter. Prayer accepted. Registry to list these matters after 2 weeks, 3 weeks, on a date to be fixed by it. In the meantime,
Lordship, that in virtual hearing may not, it's not possible to conduct.
Who asked you? We gave you time till 6 to file an affidavit. Today we could have resolved the matter.
Yes,
it's
Lordship.
because of your default. Don't take advantage of that.
Madam, 17th
List this matter again after 2 weeks. List this matter again on 8/1/2025.
I'm so grateful to lordship.
8/1/2025. Till the next date of listing, the interim orders would be passed. It is provided that no further adjournment would be provided in the matter. And the affidavit now required to be filed by the petitioner shall be so filed on or before. Today is 12, no?
22nd, man. On 22nd, I will file.
22nd will not be here. You can file it on 23rd.
23rd. I'm so sorry, man. On 17th, on 17th, some protection, man. I could not.
We will nothing doing.
Man, 17th,
what protection we have given? We have already given nothing.
Man,
or you argue the matter, argue out the matter, we will pass finally dispose it of if required today itself.
I bow down to Lordship. Let the my lord, I want maybe come before Lordship. Then my Lordship, and my lord, I want the matter to be resolved by your Lordship, my lord. So my lord, that.
Okay, thank you.
But I'm grateful. I'm grateful to Lordship.
Yeah, please, man.
Who is appearing for response number 2? Mr. Tato?
Mine.
Liglana has entered appearance on behalf of the respond number 2. Accordingly, service is complete. It raised it to list these matters for admission hearing when? After 10 days?
Your
After
Lordship,
2 weeks?
Your Lordship, this matter has been fixed for supplementary hearing, Your Lordship.
What is that supplementary?
For hearing, Your Lordship. It was already
Oh,
admitted.
it was for hearing. Okay, okay. So today it's for hearing. Then.
Yes, Your Lordship.
Okay. Hearing list. Okay, fine, stop.
This matter is we are assailing the order passed by the framing of charge order passed by the learned district and session court, now special court, Basar. What happened in this matter is that an FIR was filed initially. FIR is at page 18. FIR was filed by the brother of the victim, the deceased victim. That is at page 18.
Page?
18. 20.
What is the stage? Charges have been framed.
Yes, ma'am.
Trial is stayed over.
Yes.
My lord,
There is a order of
state. Actually, what happened is that initially, upon the registration of this FIR under 306 and 34 IPC against me and my wife, the charge sheet has been filed. Initial charge sheet.
Okay, this is under stay. You can have it after vacations. What is the hard? As prayed for by the Learned Council for the parties, registered to list this matter again on 21/1/2025 for hearing.
Well, there is an interim.
Interim order shall continue till the next date of this. Yes, Mr. Modi. इसमें ऑर्डर अगर आगे पास किया है उसको कैंसिल कर देने बोला. Yes.
I'm not doing the report.
Can't help it.
In this, she was
No.
was the,
Now you want a decision.
Just the decision.
6-5.
I remember that the case was already decided by the deputy commissioner in 2005.
You have any grievance? Go before the district judge, senior district judge. File an appeal. Finish it off.
My lord, because this is regarding the question of the jurisdiction. So
Jurisdiction can't it be taken up there? That this order was already that appeal is everything you can have. Why should we come in after when you have been provided with an appeal, provision for an appeal? What is the other case number pending? There is another case pending before this court.
Yes, my lord.
What is that?
Actually, I'm not, record is not with me. My lord, maybe on Wednesday.
As let the earlier order remain. Earlier order remain. Because लिया है उसको बोलना वही मान ले. As per to. Okay, 18. Anything more? File मिला है. Did no. Oh, we'll have it at 2. 2. Huh? Pass the orders. Madam, listen. वो complete हो गया क्या अपना? हाँ? अब तो pending नहीं है कुछ. तो ये लीजिए. Yeah, ठीक है. अंदर में दे देगा. We'll pass the orders. Dispose of करते हैं. We'll pass the orders. Mild. और कुछ? 2 o'clock. कितना तो है पेंडिंग में? नहीं ये तो छोड़िए. हाँ.
17, my lord.
हाँ?
17.
We will have it at 2. Who is there? Who is there for the petitioner?
Lampung.
He is not here. Why?
I don't know. My lord, either my lord, entry may be vacated and this matter may be listed after 2 weeks or 3 weeks.
No, we'll finish up the matter. What is entry vacation is equal to?
My lord.
Why give him? We'll kill him fully or will not? Kill him.
My-
We'll just-
we fear the
My lord,
family
may I
left-
mention item number 34?
Yes.
Yes. Item number 34, may I mention, my lord?
Item number? Item
34.
number? 34?
34. Yes,
Already mentioned by somebody.
Actually.
With your consent,
main
it was
counsel
told.
is-
With your consent, it was
Yes,
said
my
that
lord.
it is mentioned.
It has already adjourned. Actually, arguing
No.
counsel is not available today due to his throat problem.
I can't hear you, but it was mentioned before me saying that the consent was taken from the petitioner, right? Item number 34. Whenever.
Yes, ma'am.
It was said that I had objected, then they said that no, the consent of the petitioner is also taken. You're for the petitioner.
Yes, ma'am.
Your consent,
But
you
I
have
am
not
not
given any
main counsel.
consent. Huh? You have not given consent.
I'm not. No. I'm given, but
Then
PK
what is
Gautam, if
Then it's all. At 2 we'll come back. If your officers does not know how to deal with a court, we will explain it to them how to deal. And there is the latest circular of the Government of India. Now, what is the vigilance case pending against him? What is the case pending against him now? That criminal case is over. Seems.
It is over.
taken up by my.
Nawam. Where is Nawam?
Now
He's coming on Monday. Okay. In terms of the directions passed by this court, by order dated 4/12/2024, Mr. Tapin has placed, as Tapin, learned senior government advocate, has placed before this court the findings of the DPC held on 22/5/2027 and 16/12/2019 in respect of the suitability of the petitioner herein for promotion to the APCS senior grade and APCS administrative grade. So, Mr. Tapin submits that the matter was entrusted to him only today and accordingly submits that the court would be pleased to take this matter up again on Tuesday. So, prayer accepted. Tuesday, you have any problem?
He was already serving in APCS senior grade. It should have been APCS admin grade and APCS.
I've only noted what is here.
Yes.
I've only noted what is here. Maybe we'll see to it. That will not make any difference, man. Kelgalas. Prayer is accepted. Registered to list this matter again on Tuesday. The seal covers produced by Mr. Tapin is returned with and the same would be again placed before this court on the next date of listing. And go through this. Mr. Tapin, Janaki Raman is the law that is holding the field. And if you go through that, if these vigilance cases and all cannot be a bar. And this person has retired. But because of the prescription in Janaki Raman, because the now law is very settled. Once you retire, you cannot be promoted with retrospective effect. But this is a case because it was in seal cover. He could not be promoted, right? So opening of the seal cover and the retrospective promotion here, from the date his junior was promoted, notional fixation till the date of retirement, and then the revision in the pension. That's the only thing. And these documents are not confidential. It's confidential with the petitioner, but when the court requires it, you cannot withhold it. Get my point? And mere pendency of an appeal will not be a bar until and unless you don't have a stay there. I'm sorry, ma'am, but this is the position. And never, when you are an officer of the court, acting as an officer of the court, always be right. I'm not asking you to do an illegal thing. Illegal thing, please don't succumb. Be bold, ask them that, no, this is the law, give it to me. Anyway, fine.
Item number 3 to 5.
There were some other small matters left.
10 minutes.
Huh?
10 minutes.
2 minutes, sir, just finish.
Well, 10 is a contempt matter, my lord.
Yes. What is the instruction, madam? Oh.
Well, in this case, my lord, I just
Money has come, it has not reached you.
no, my lord, money they have paid, some they have paid, but then not asked for the direction, my lord. They were supposed to assess as per the Lara Act. They have not.
Madam, sir, they have given you around 10 crores now deposited. We just want to know what happened to that 10
Not
crores.
only 3 crores, not there's two components they have mentioned here, but we are only for one component.
3 crores.
3
I had told that in the morning, but everybody disputed that. Anyway, this was. Ma'am, why was this not brought to the notice of this court? No problem. Now you come to the order. Where is the order?
What I spell it in my application is page 22. It starts from
22.
14, but operative portion is in page
22.
22. Paragraph 5, my lord.
It follows the earlier decision.
Yes, my lord. And earlier decision, my lord, also we have enforced here, my lord.
You can come to para 21, page 21.
21. Yes, madam, page 21. Madam.
So Solicium has not been incorporated?
Well, Solicium also not incorporated, and other is that.
Yes, Mr. Doctor, Solicium has been incorporated.
Yeah, Lordship, I see the reply of a deputy commissioner. They have filed the total assessment. And if I see, they have only included only 7%. They have paid only 7%. The rest of the land owners, well, they are right in page, but I'm just take to that relevant procedure. The affidavit filed by respondent 1, 2, 3, and 4.
Affidavits can. One, two.
1, 2, 3, and 4. Page the assessment which they have done as per the direction, my lord, is in page 74.
74.
Yes, my lord. This was the location. The project is for Damben Bruni ICPR. Number 1, declaration such and such, my lord. The total area is 1,68,000 or 6,800 square meters on page 74.
Have you filed a reply to this? Have you filed a reply to this?
We have not filed.
Filed. MS G. Learned Counsel for the petitioner, for the respondent deputy commissioner, on request made of a learned government advocate, on request made by the government, has received instructions. Request made by this court has received instructions as to whether had received instructions that the amount deposited by the NHIDCL authorities have since been disbursed to the claimants, public petitioners. Also, Mr. The Mount Learned Counsel for the petitioner. You're for all the petitioners?
Yes, sir.
Petitioners has submitted that the said amount has been received by the petitioner. However, he contends that the directions passed by this court, while the order violation of which is alleged in the present contempt petition, has not been complied in the manner required. So accordingly, he submits that he be granted 2 weeks' time to bring on record the rejoinder affidavit on behalf of the petitioners to the affidavits filed by the respondents in the matter, state respondents in the matter. Also, prayer accepted. The registry to list these matters again after 2 weeks, enabling Mr. Ma to bring on record the rejoinder on behalf of the said of the petitioners to the affidavit filed by the state respondents. Also, Madam, you can keep it in your file. Whenever we require it, you can just keep it. You can, whoever is appearing, or we'll keep it in the file. We'll keep it in the file. We'll keep it. Keep it inside, huh? Let's put it inside. Inside. Also, registry to list this matters after 2 weeks, on a date to be fixed by. Thank you, ma'am.
Okay.
Yes, what happened? Mr. L. Permit, Learned Counsel, Standing Counsel Power Department has placed before this court a sanction order dated 13/12/2024, by which, in terms of the directions passed by this court-wide order dated 25/7/2024, the provisional pension sanctioned to the petitioner for the period 1/5/2021 to 31/10/2024 has been continued. Also, in the above view of the matter, it is provided that the said pension, provisional pension, shall be continued to be paid to the petitioner herein till disposal, till finalization of his pension and issuance of the pension payment orders by the authority concerned. Also, registry to list this matter again after 4 weeks, enabling Mr. Permit to bring on record his stand by way of stand of the department by way of filing an affidavit. A copy of the order dated, sanction order dated 13/12/2024 is kept on record and marked as X for the purpose of identification. This is the way we should work. I'm really appreciative of that. I appreciate for that. Good. Thank you. None appears. The none appears for the petition on call. Mr. B. Pincha, Learned. Standing Counsel.
RD Department, Rural Development.
Rural Development Department is present. Also, the challenge in the present proceedings is to an NIT is to a corrigendum issued by the respondent authorities amending the eligibility criteria as well as the works so tendered by MIT dated 10/10/2024. The petitioner has in the writ petition contended that the corrigendum was issued on 11/10/2020, was published in the newspapers on 11/10/2024, and the last date for submission of bids was 15, na?
Yes,
15,
yes, 15.
10/2024. And accordingly, on account of the short duration, he was not in a position to procure the bid documents and submit his bid in the matter. So the respondents have filed an affidavit in the matter on 4 December 2024, and therein have explained as to why the corrigendum was called upon to be so issued, and also that only a minimum 3 days period is required to be given for receipt of tenders in pursuance to issuance of any corrigendum amendment. Also, the respondents have also contended that that although it was holidays on 11th and 12th, the offices were kept open and tender documents were being received by the intending bidders, and in support thereof have brought on record a list of such bids, a list of
Sale register,
wherein it has been reflected that even on 11th and 12th, the bid documents were procured by the intending bidders. So, it is also to be noted that the present writ petition was filed on 30/10/2024, whereas the last date for submission of the bids in pursuance to the tender process so initiated was on 15/10/2024. So it is also being noted that the bidders found suitable were issued with the work orders on 24/10/2024. Also, in view of the above position and considering the fact that none has appeared for the petition in the matter, this court is restraining itself from proceeding to dispose of the writ petition on merits. However, on account of non-representation of the petitioner when the matter was even on second call of the matter today, the writ petition stands dismissed. So, any interim order, no interim order?
There was an interim order.
The interim order passed earlier, but that was only to the
Not to
extent that
finalize.
if not given.
Yes.
Interim order passed by this court, while order dated 1/11/2024 stands vacated.
Much of it. My lords. Lordship, I am impugning the order passed by Deputy Commissioner Lower Sand, number 45.
What is this proceeding?
Lordship, the brief fact of the case is that the petitioner here is.
Madam, what is this proceeding?
So this is a little bit confusing, but then Lordship, it is clear from here that Lordship, she is a renter, but trying to forcefully remain there. And as per the complaint lodged in before the Deputy Commissioner, the private respondent, Lordship, the real owner of this
But
property.
if she has anything, she should go before the real owner. if he is a tenant, there are proceedings before the court.
Civil court.
Civil court. How can the deputy commissioner come in? What is his power?
This is confusing, Lordship, even I say, Lordship.
Also,
But then here also, Lordship.
Madam, you have your instructions. Heard Mr.
Arimo.
Learned counsel for the petitioner and also Ms. You are appearing for? Ms. Etta, you are appearing for?
Lordship for Deputy Commissioner.
Mr. Kanduk, learned counsel. Who will be appearing for one? You will be appearing for one also?
One and Lordship 5. 1 and 4. 1, 4 and 5, Lordship.
1, 4 and 5. Heard Mr. So-and-so, learned counsel for the petitioner, and also heard Mr. MS J.T., learned counsel, appearing for respond number 1, 3, and 4, and Mr. Kanduk, learned standing counsel, land management department, appearing for respond number 2.
2 and 3.
2 and 3.
I will be for 1, 4 and 5, Lordship.
Ms. Ete submits that she be granted of 2 days time, 4 days time, to 5 days, 4 days time to receive her instruction in the matter. Post op. Perusal of the order dated 6/12/2024 impugned in the present proceeding. From a perusal of the order dated 6/12/2024, Madam का पीछे लिखिएगा, उसके बाद ये लिखना. It is not clear as to the provisions of law which were invoked by the respondent number. On a perusal of the order dated 6/12/2024, it is revealed that the Deputy Commissioner had issued this said order in relation to a private dispute between the petitioner and the respondent number 6. It is not clear from the said order as to the source of power for passing such order. In view of the above position, Ms. Ete submits that she would receive her instructions in the matter and prays that the matter be listed again on 18. Will be comfortable or 17? 17.
Lordship, page 19, Lordship.
17. 17.
Lordship,
17, 12, 2024. We can, if you have to have it, we'll have it. 17, 12, 2024.
Otherwise, Lordship, 18. Right.
18, Madam is not here. You're having some problem. You'll be here. Then 18, 18, 18, 12, 2024. Push up. Till the next returnable date, it is directed that no coercive action against the petitioner herein shall be so taken in pursuance to the order dated 6/12/2024 passed by the respondent number 4 impugned in the present proceedings. Madam, you have your instructions, we'll finish. It seems to be that for a private dispute, he has come in. Let's see.
Definitely.
For motions लिखिएगा madam. List on Tuesday
Yes,
for
well,
motions.
Well, the act of
Mr. Tara,
my lord.
I'm seeing this file for the first time. Give me the facts. Then we'll go to the act.
No, but just I'm trying to project it. My lord, what had happened? There was a case of merger, my lord. Then
Same thing that day we did, that same matter.
yes, my lord. Then what had happened? The State Election Commission has a merger value. Against that, my lord, under
Mr. Saikia had that day highlighted that there is
Yes.
an appeal pending before
Yes.
the Chief Secretary.
No, my lord, that what happens under section 1,
Show me.
section 6. Can we have this volume? Volume 12.
First, the election tribunal passes an order.
Upholding
and that-
our merger value.
And thereafter the appeal lies to?
appeal lies to Chief Secretary,
Chief
State Government under Section 6(1). Page 1. Page 1. No, that is not. Where did I give this?
Members of the local body disqualification on ground of defection act.
Correct.
Then
Now, my lord, what happens is, now this appeal was filed before the Chief Secretary, Learned Chief Secretary. Now, no notice was issued. No notice was issued to us, and he proceeded to third ex parte, and the decision of the State Election Commission rendered on 1/11/2024 was stayed. Now the question is, the legal question, the formulation is whether this particular act, the members of AP urban local bodies disqualification on ground of defection act 2014 provides power to the appellate authority to stay the orders. And these
when was the order of stay passed?
Therefore, yesterday, my lord. Kindly see the conduct, my lord.
Where is that order? 10-12.
10-12. The matter was heard on 11, the connected matter. And my lord, I'm too scared also to appear in this matter because all machineries are against the petitioners. But somehow I have a dare to appear. Anyway, my lord, that is none of our concern. Now, my lord, only question of law, my lord, I'm praying for stay order is kindly take subsection 2 of section 6. And I will have a comparison and I have placed one small judgment on this, my lord.
When was the appeal filed?
Appeal was filed on 18/11. There is no quarrel on that. My lord will kindly come to 6. Subsection 2. Kindly page 4, my lord.
Chief Secretary.
The Chief Secretary shall follow a summary procedure of taking evidence and hearing the parties concerned in accordance with this act and other laws concerning dispensation of natural justice. Now, there is no ambiguity in the language. Once the appeal is filed, you ought to resort to the summary procedure by issuing notice to us. You have not issued. Now, my lord, kindly appreciate.
Date of filing of the appeal?
18.
18/11.
18/11. Now, my lord, kindly appreciate. In this order, in this act, no explicit power is granted to the appellate authority to stay the orders of the State Election Commission. Now, my lord, have a metaphor. Let us have a comparison. My lord, kindly provide whole and 80 report. The statute has not provided him the power to stay. Page 162, sir, 175. Well, that is Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003, State Act. For a purpose I am referring to, kindly come to page 169, State Section 12, Appeal Provision. Page 169. Kindly come. Section 12 says, where an appeal is preferred from an order of the state officer, the appellate authority may stay the enforcement of such order. Now, my lord, kindly have this now. Now, no power is provided. Now, therefore, my lord, when the statute does not provide you the power, and subsection 2, section 6 of the Act says that concerning the principle of natural justice, you must follow the summary procedure. And my lord, kindly come to impugn order. The beauty of this impugn order, I tell you. My lord, kindly come to page 45, straight, paragraph 4. Thankfully, my lord, the ground has been pasted here. From there, I could make out a lot of things. G. Biswanathan, Rajendra Singh Rana judgment will come. And these are all in my favor, what they have done. Therefore, under the provisions of section 6, subsection 1 and section 2 of the members of Arunachal Pradesh, urban local bodies disqualification on ground of defection act 2014, The representation of the deponents are hereby admitted for a thorough hearing in accordance with the Act and other laws.
Okay, what is the decision you want to review?
No, here I want to point out one thing. No notice has been issued, my lord. Can you see?
Okay, fine.
Even has not directed the
He has not come to a final conclusion.
Yes, but even this cannot be called as a procedural aberration. Lord. He knows. Well, that no. Where is that page? 2010, 9 SSC page 437. That Kasina judgment. Yeah? Where is
437.
437 paragraph. This 9 you have brought. 10 kindly brought. 9. Huh. 1 second. Where is this page? But that is when the statute does not provide you the power to review the order or the pass this, you cannot do this on that proposal. So therefore, prima facie, this is a case called for intervention. You cannot do this.
Yes, Mr. Daman.
The power is not given, but the summary procedure has to be allocated in the inherent power must be there, no is not given in the apart from that, also, there are other something. By this order, though the order commission has been displayed and been brought out. The same time, notice has been issued to the party.
Where is the notice?
And my friend will not issue, but it has been issued.
No. Accordingly, notice be issued for hearing of the both parties on 10 January. Okay. But Mr. T.T. Nara, learned counsel for the petitioner, and also Mr. S. Tapin, learned counsel appearing for the state respondents. So, the challenge in the present proceeding is to an order dated 10/12/2024 passed by the appellate authority under the provisions of the Arunachal Pradesh.
The members of Arunachal Pradesh urban local
bodies bracketed disqualification on ground of defection bracket over Act 2014. Also, it is the submission of Mr. Tara by referring to the provisions of Section 6, 1 and 2. Subsection 2 of Section 1 of Section 6 that the appellate authority on receipt of an appeal against a decision taken by the state election commissioner in the matter is to follow a summary procedure of taking evidence and hearing the parties concerned in accordance with this act and other laws concerning dispensation of natural justice. The decision on the appeal shall be published in the official gazette of the state. Also, a close perusal of the provisions of Section 6(1) and subsection 1 and subsection 2 of Section 6 would go to reveal that the Chief Secretary, as the appellate authority, before deciding on the appeal so instituted before him against a decision of the state election commissioner, has to grant a hearing to all concerned, and thereafter by following a summary procedure come to a conclusion with regard summary procedure, decide the appeal so referred before him. Full stop. The issue arising in the present proceeding is as to whether during the pendency of the said appeal it would be open for the appellate authority to stay the order so impugned before him. Full stop. The said issue would require a further detailed consideration, and accordingly the matter is directed to be listed again on Tuesday. Let us also see. Tuesday we'll do something. Tuesday.
Until then, status quo.
Nothing is going to happen. It's on 10th.
But I have
Neither, neither.
No,
I know, got it. Tuesday we'll see.
no, my lord, my lord, why this has been filed?
Mr. Tara, only on Tuesday. Prima facie, I just want to satisfy myself and you also satisfy me
Correct.
that when an appeal is preferred, like a power, when in the General Clauses Act, power to appoint also brings with the power to suspend and dismiss. So just want to examine that aspect of the matter, whether it is, we'll have it on Tuesday, we'll pass orders on that day.
Then kindly protect us, because
What harm is caused to you? Tell me.
No.
What harm is caused to you? You are councillor?
I am councillor.
Then?
I am councillor, but what I got to know,
They
from
can't
close-
pass an order before 10th now.
Ah.
They can't pass an order before 10th. Mr. Tara, I have already gone through the order. You have showed me 6-2. By appreciating 6-2, I have appreciated the order. And the order says 10/1/2025 is the next day. Nothing is going to happen. We'll have it on Tuesday. We'll see what is going to happen on that day. Register to list this matter again on Tuesday for motions.
Great.
Don't worry. Nothing is there. You are councillor on 10th. You are councillor today and you will be a councillor on
No,
Tuesday
but
also.
I can understand, my lord, that particular point. I understand, but the predicament is that in my opening
An
submissions,
order which is neither here nor there. How can it harm you?
my lord, I kindly make this one small observation, if I request from my heart, my lord, only a prayer from the heart. Any consequential order shall be subject to outcome of this writ petition.
We cannot pass a consequential order. Let them pass the order. I am here. I am here at least till 20th, 19th. Mr. Tara, I am here till 19th. Let them pass that order in violation of the rules. Why stay? I'll set it aside on the first day. I'll use my discretionary power.
My lord, kindly observe predicament of the clients, my lord.
You see,
My lord, only I
see
can
that may even cause problem for you. When they can't do it under 6-1 and 6-2, and they having committed by themselves to have the hearing on 10/1/2025, what is going to happen in between? If something happens in between, Russian, we are here. Russian, we are here. Now this has gone in. So it will not take much time. It will take me 2 minutes. I'll immediately just tell me, sir, this is the notice. 6-2, finished. Why stay? We'll set it aside.
Well, list it before this bench.
But let it be before any bench.
Any bench, my lord.
That is not my discretion.
Grateful, my lord.
Bench, that matter is yours only. You only argued. Decision of the Honorable Chief Justice, Guwahati High Court.
Correct.
It's the Chief Justice's discretion where matters come.
Master of the roster.
Master of the roster.
Great.
We were on the opposite sides that day.
Both of us. All right.
No. हाँ तो नहीं देंगे सब हो गया ना. Yes. Mr. Tapin, that day I was trying to get the thing in Seritam. So maybe I was disturbing Mr. Kashyap a lot. So let him have the first attack and let him go by in his Seritam. Thereafter, I'll come back to you.
Yeah, Lordship,
Mr. Kashyap,
Yeah.
let us, facts are basically known now. We have read it also, but
Yeah.
I would request you to go back to the starting point and then take me through.
Lordship,
Another one.
prepared a list of dates
Good.
to make it very convenient for you, so
Mm.
that, I will quickly go through it.
Mm.
And then, Your Lordship, there are few documents. So,
what I'll do, your lordship, is in fact, not even refer to this first. I'll just tell you what exactly my case is.
No, you give me the starting point.
Yeah, the starting point, your lordship, for me, if you go through the list of dates.
16/10/2008.
Yeah, if you go
Have you
through
given
the-
a copy to Mr. Tapin?
Yeah, just give me. The list of dates, your lordship, if you go to the third page.
No, let us go from the first page.
Your lordship, why I'm saying, where did it start? The present petition, the roots lie in phase 2, what I have called phase 2. In fact, your lordship was very right in pointing out what do we have to do with 101, PIL 101. I'll point out the relevance of 101 at the end, your lordship. The present matter, its roots lie in the fact that.
I'm not interested. I want the starting point of the whole.
Oh, the whole
dispute.
thing. That is
because you
101.
are relying on 101.
Yes.
Please.
I have to, because they are relying for the defense.
Okay.
On 101. Okay.
And 101 was a case wherein he
PIL.
came up before this court saying, don't do this.
Exactly, your lordship.
Yes.
So, your
start.
lordship, phase 1, this matter is in phase 4 phases, your lordship. First phase, I say, is land acquisition notification, award of contract, proposed change in alignment, 1E, that is 31 kilometers to 15.8 kilometers, assessment of land compensation, and the final order and judgment on 18/9/2014 in the PIL 101/2013. Your lordship, the importance of 101 is that we came in, by we I say, the petitioners here, 2 of them were party there also. But that is not relevant. What is relevant is the PIL was to request the state to continue building the road as per the old alignment and as per the concession agreement with the contractor, which was also an old alignment, and the land acquisition notice of 4th April, which was also an old alignment, 4th April 2012. Subsequently, your lordship, the petitioners came to know that a new alignment is being proposed. And they came to court saying that please don't go to the new alignment, go to the old alignment.
Why?
Because in 2008, when this scheme was thought of or germinated, a new alignment.
The road is from Sepa to Rilo.
Sepa to when the total road is from Sepa to Rilo is the new alignment. The following existing alignment is Sepa to Rilo, but the one that we are concerned with
may follow the
Sede
existing.
to Pakro. Lordship, the Sede to Relo is a larger road.
Okay.
There is a smaller segment which is Sede to
No,
Pakro.
what is the total road called from point to point?
Total road that is relevant to us is 70 kilometers.
What is that road called? Point to point?
Point to point, it is in the alignment. I'll just tell you.
Spelling?
Nichibu to Hoj. Nichibu to Hoj.
N-A? H-O-J. This is?
No, that is a complete transnational highway. The one relevant to us is in this state.
Total road.
That 311 kilometers.
Now, the petitioner's dispute is pertaining to which segment?
Segment 1E. That is Sede to Pakro.
Sede to Pakro.
There are 2 routes between Sede to Pakro. One is the old route, which is 31 kilometers, and the new alignment, which is 15 kilometers.
And what is the old alignment called?
The same, Sede to Pakro.
1E.
1E. It is called. Lordship, I'll tell you what it's called. And it was made for. Lordship, there is a specific label. It is called segment 127.127 to 153.
That's the old one.
That's the old one.
Okay.
And the new, for the same 2 points, it is called 0 to 0.15.
Okay, the old one is?
Sede to Pakro.
Okay, that you gave me a 127 something?
127 to 153.
127 to?
153, I think.
53 kilometers.
8 kilometers. Those are measuring points also, and it's measured in kilometers.
And the new one is 1E.
It's called, no, both are called 1E, your lordship.
Oh, okay, both are called 1E.
Both are called 1E.
And new one is 0.
New is 0 to 15.8.
15.8 kilometer.
Yeah. Lordship, if you see page number 19 in the compilation, it's given very clearly. Page number 19 in the compilation. Page number 26, sorry. Page number 26 in the compilation.
How did I find it?
Right.
Okay, we'll come to that. So 0 to 15.8 and the old one is 1.
The new alignment is labeled as 0 to 15.8 and the old alignment between the same 2 points is labeled as 127 to 154. 154.
And this is total, how much kilometers was there?
Old alignment 31 kilometers.
New alignment,
15.8 kilometers.
Okay. Okay. Now, the government, once it formulated this 31 kilometer thing,
Right.
it had issued some notifications.
Yes, Your Lordship.
When was the first notification?
The first notification was 4th April 2012, I think. The land acquisition notification. There were earlier notifications, preliminary, but this is the operational notification.
LA notification.
Yes. Land
This is
acquisition.
under the
Under the old
Act,
Act,
1894.
section, yeah, section 10, I think.
1894. Okay. How was the land described, the area described?
Just the way exactly I have told Your Lordship.
127 to 51.
It was a line diagram made.
That line diagram, this is line diagram is of?
Line diagram of the road alignments.
When is it? When was it?
This was as part of the, this was submitted as part of the
LA notification.
alignment that was submitted to the court in PIL 1.
I don't want that.
Yeah.
When the matter was first advertised or the notification issued,
2012, Your Lordship.
what was the exact measurement of
311 kilometers with 70 kilometers oblique 31 kilometers. The 15 kilometers was not advertised.
Okay. So you mean to say that 127 kilometer to 154 kilometer was
advertised.
included?
Yes.
Yes.
I can in fact, when I go through it, I'll show you the advertisement.
Okay, fine. We'll come to that. Let us go in seriatim.
Yes, yes.
So this land notification, LA notification was issued.
Yes.
And when was this process completed? 4/4/2012 notification process completed. Land
Your
taken over?
Lordship, what happened that this, because of change of alignment, we came to court and a stay order was issued on the segment.
You came to court in sometime in 2013.
2013.
So within this 1 year, nothing had happened.
No, a lot had happened, Your Lordship. The money was sanctioned, money was received, and some disbursement has also taken.
So who received the money? You received
the old
money?
alignment, and 2 of the parties here were also received some money on the old alignment. They had some property on the old alignment.
So which are the petitioners who received?
One is Mr. Natung.
Petition number?
I'll just. Actually, I would have covered all this very systematically. Unfortunately, what happens, I'm not.
You're not.
I'm not having the assistance that I have normally. Which I need the writ petition. Parties are there, no, in the writ petition. Contempt petition. Yes.
That assistance is invaluable.
I know, Your Lordship. I know. I mean,
we have been through that.
So, Your Lordship, one is Mr. Rojo Natung. Party
number?
3.
Petition number?
Item number 3. Petition number 3.
In WPC?
In WPC
359.
15. In contempt 15.
No.
Contempt petition 15.
In the writ petition.
You are talking of 101?
No. The present pending writ.
359.
359.
Okay. 359. Really, my familiarity with the names also is a bit of a problem, Your Lordship. But concept are very clear. Rojo Natung is 3 in this also, your lordship.
359.
359 also he is 3.
And another one?
And the other one, I am not so sure at the moment, but as I go through it, I'll be able to tell you.
Okay.
Okay.
Then what
But
happened?
Rojo Natung was the main guy. He was the main person even in the.
Okay. So two of the petitioners got it.
Yeah.
And then this should have been the end of the matter. But
I'll tell you, Lordship, if you just give me half a minute, what exactly the problem is. The problem is compensation came on the old alignment. The secretary passed an order sanctioning the compensation of 49 crores, specifically saying it's on the old alignment. But when the matter came to court in 101, they filed all the case papers they have filed here also, saying that we have paid compensation on the new alignment. We is not the right word, your lordship. The petitioners there in the PIL 101 argued that this is not correct. And on the same papers, and I have produced both the documents in my submissions, they said that this matter has to be adjudicated upon. And there were long arguments when the state gave up its contention that it is on the.
We'll come to that.
No, your lordship.
No, we'll come to that. I'm just trying to understand. So now we come to the stage when
Sir, your lordship, the main problem, may I just mention half a minute actually. The main problem comes from the money that was received came on the old alignment, and most of it was dispersed, rightly or wrongly. Now, when the new alignment was allowed, in the court they filed it as a proposed alignment. The diagram I showed you, the shorter line, they have written proposed alignment. But the court then allowed that alignment. When the court allowed that alignment, the money had already gone. I'm just trying to tell you what
money had gone to the people.
To the people on the old alignment. And as I take you through the documents, when they admitted in 260, 154, which is the next series of litigation, they again admitted that, okay, we are issuing a notification. We were on old alignment, not on new alignment. In 17, they have filed on affidavit saying that survey was done only on old alignment, and subsequently advertisement was done, survey was done, and payment was done on old alignment. On affidavit, they have said in their counter
Deputy Commissioner's affidavit.
DC's affidavit. ADC or DC, I don't know.
Whoever, it's a district authority.
Yeah, R7 there. The point I'm making is, multiple times they have used the same documents to try to defend themselves. And then my larger point, your lordship, is their difficulty, and they have mentioned it. They tried to get the central government to foot the bill. Central government refused to do that. And since then, this thing is going on.
I got it.
Right.
That's what you submitted the other day also.
Yeah.
Now, Mr. Kashyap, just give me an idea. Now, the new alignment thing fructified after the PIL.
After the PIL, it fructified means it became the legitimate new alignment, alignment of the entire 311.
Okay. Now you tell me, once that new alignment thing was finalized, what happened?
In May of, around 5th May 2015, the order came in September 2014. In May of 15, we who were in our land suddenly found contractors, people coming into our land and taking it over, which is when, and they gave us a letter from the DC addressed to the contractor saying, you go ahead with the construction, all compensation has been paid. In fact, that is where the story really starts for the present. This thing is what I was trying to take you to, that the May 2015, physically we came to know that something has happened and we were handed over a letter. Against that letter, we came to court in 260 of 2014, the writ petition. And there again the state said, oh, we give this up.
Let us. Now the state had moved all along in respect of the old alignment. LAs were issued, land acquisition notifications were issued on the old alignment. PIL, the new alignment comes into being. Now, where is the land acquisition notification?
I'll show you. Kindly come to page,
Affidavit.
the new alignment notification was issued in 2016. While the petitioners were before your lordships.
Where did I get it?
I'm just taking it. Just
The convenience compilation or in the repetition?
It's in the compilation, it's in repetition also, but I am taking you to the compilation.
That'll do.
I'm taking you to the compilation. 2016. Exactly. Now, Lordship, page 81, 82. There are two these things. Lordship, page 82 is the original, then the other one is type, is black. This is the typed one. Preliminary notification, Lordship, 19th August 2016.
Give me the 2013 Act. 2013 declaration.
This is as per section 11, your lordship. And this notification is for the newer line. Very clearly. And subsequent to this notification, they conducted a survey. And prepared a
No, new one, 13.
lordship.
No, it's okay. Then under 12, a preliminary survey was made.
Yes, your lordship.
Then
your lordship, that same was a tabulation was done. As per the order into.
now one factor comes in. When did you get your LPC? Your LPCs were first issued to you?
Were issued before this May date.
In your names.
In our name, it was before this date of.
When?
Exact date I take you from.
Before the date of issuance of the section 11 notification.
Definitely, yes. Much before. Even
2015.
Before, maybe 14 or 15, your lordship. And I tell you why we know this, because we were physically in the fields when these people came. And that is how we came to know. Otherwise, we had no way of knowing that this is our alignment. For these alignments, matching them to the ground is not an easy task.
Okay, then what happened?
Then your lordship, we went to, we came to your lordships for protection under 260, and while we were they cancelled our LPCs.
No, forget it. Now this preliminary notification survey.
No, the road has been made, your lordship.
Huh?
The road has been.
Naturally, got it. But the thing is, we'll have to understand. Let us recreate the whole crime scene, as it is called. Let us, because they had infringed upon your land. An offense was committed at that point of time. Okay, fine. Now, we are at the stage of the issuance of the notification and the survey. Then what happened?
Then your lordship.
2016.
Honorable, this notification was mentioned by them in an additional affidavit.
Where?
In the writ petition 260.
Come, let's go to that.
Okay, so let me take you to the writ petition 260. It's in the compilation only.
Yes, I'm in the compilation.
Yes. So, page 57. This is the document, your lordship, against which we went. So I think it's
Page
important
50?
to see that page 57.
Number.
Right, second, this numbering is 57.
This is WPC 321, 2019.
I am looking at the compilation, Your Lordship. Compilation, yeah, this is right. That I have taken it from this source. Why I have got this page is that this has been attached in this.
57.
document. Yes, page 57. You will go to page 58, basically. 57 is the cover page.
It's an order of the High Court.
No, Your Lordship, this is the order against which, this is the impugned order for which we came into 60.
Okay.
So it's important for me
Yes,
to show you
this
this.
is one. Yes, yes.
So-
58, 12/5/2015.
That's right, Your Lordship. I read Your Lordship, if you allow me. It has come to the notice of understanding that few persons with their ill motive are trying to obstruct the construction of highway and alignment 1E, Cedar to Pakro. And he mentions the alignment here, 2630 something. And he takes name of 4 persons, which is basically petitioners before yourself. Also, the compensation of above mentioned, this is important. He says compensation for the above mentioned stretch has been already assessed and paid to the individuals. So we come against this. While the matter is pending.
So before issuance of this Section 11 notification,
Yes.
they had issued this 12/5/2015
Yes.
notification.
Well, this is the order he calls.
Okay, order.
Yeah, yeah. And this is issued to Your Lordship. We received it from the
whoever it is.
Yeah,
It's
from
something
the
which is there.
Yeah. That's
So
right.
now this and 19/8/2016 does not match. If you have already paid, why was the
Lordship, they are repeating what they are. No, Your Lordship, you are right. This is exactly what my case is. In 101, they first said we have paid, then they abandoned that argument, and the court has held that the money has been received on old alignment very clearly.
Okay, come, let's just take me
Should
to
I finish the 154?
No, just take me to that.
To the 101?
101, wherein it has been said that the old alignment.
Your
has been
Lordship, just a minute. Page 32, Your Lordship. Just a minute, yes. You want me to take you to the order or to the
No,
documents? To the order?
Order.
Okay, Your Lordship, I'm taking. Your Lordship, page 49. Page 49.
Okay, that is the starting.
This is the starting. I take you to para 4, page 50.
Para 4.
Para 4, page 50. The Arunachal Pradesh government para 4, Your Lordship, has filed an affidavit admitting that survey was conducted by the government to upgrade the BRO road from Cedar to Pakro segment to make it a 2-lane road and also to pass through the villages as stated. This is the villages not we, Your Lordship, the PIL petitioners were. It is also admitted that lands have been acquired pursuant to the said proposal and compensation has been assessed and deposited with the authorities for disbursement to landowners. However, it is stated that the Morth did not find the proposal of the state a feasible one. The Morth is asking for a different alignment. Now I take you, Your Lordship, to para 10 on page 54. Para 10, page 54. In view of above said reasons, we find that the PIL lacks merit for granting relief. The relief we were seeking is keep the old alignment, setting aside the approved plan. However, we notice that there appears to be a dire need for improving the BRO road existing in the named villages in order to have better connectivity with the townships and as well to approval highway between Cedar and Pakro. The Arunachal Pradesh government did feel the necessity of improving and upbringing BRO road as national highway. Then Your Lordship come to the end of para 11. End of para 11, I read the last line. The state of Arunachal Pradesh shall complete the said road project simultaneously with the Sede Pakro approved road, which is required to be completed by 8th responded. Accordingly, the interim stay granted. There was a stay that has been dissolved. Your Lordship, the responsibility of building this part of the road came on the state. And the PIL 101 order clearly holds.
Can
Yes,
you
Your
take me through para 11 once?
Yes, yes. Tell me which one?
Just read it.
Para-
for the petitioner.
Para 10 or para 11?
11.
Para 11. The counsel for the course of argument pointed out an extra proposal given by Chief Engineer while resolving the dispute between Your Lordship. This was a proposal for 5.4 kilometer, which I'll show you.
For
So
construction.
this was
straight
disallowed
road
by the MOF.
From a straight road from
From
Dwarka.
Dwarka to Pativa to connect to the national highway. So they proposed a new section of about 5 point something kilometers, which Morths rejected. I'll take you to the documents later. It is stated that if the said proposal is carried out and quality and width of BRO road running through the above villages will be improved as per the proposal of the state, and the proposed road between Dwala and Patawa, the modified road or construct will fulfill and cater to the needs of the regional villages who have missed the benefit of national highway. This is referring to some another alignment, Your Lordship. This is not referring to the old BRO road.
So where is that basis for that conclusion?
That conclusion, Your Lordship, on page 4, on para 4 itself. On para 4 itself.
You can come to para 6.
Para 6, Your Lordship.
The stand of the Morth.
This is Morth's stand was that this is a highly undulating area. We are proposing a new alignment, which is shorter but better in terms of technically. And this is what the High Court accepted.
The answering also villages mentioned by the petitioners like so are not in the existing BRO,
Yeah.
which is misleading to this court. Hence, bypassing of the does not arise.
Yeah.
However, the other three villages, Sede and Piran, is already connected, and Palin village is connected by adjoining road, and as such are approaching this court with unclean hands, which is liable to be dismissed with cost. Further, the final map approved by the manager, the answering respondent is after thorough survey, so and so, with design consultant, so and so, another comprehensive meeting with state. Same is not in the public. It is pertinent to mention that the existing geometry of PR road is very substandard with so and so, band, so and so. So in this section, of the existing alignment, on 315 curbs, an average 10 curb per kilometer, degree of curvature is so and so. These values show that geometry is very substandard. So general improvement to requirement realignment is prepared in conformity with the standard and specification, thereby reducing curves in order to maintain nominal speed. Denying that survey was initiated in the by them and proposed to bypass villages mentioned by the petitioner. Grave misconception with the tender process and the work execution of normal censorship.
So technically, they presented a technical case which central government supported. Para 9, last part, Your Lordship, may answer you. Para 9, the last line.
Yes.
Yes, Your Lordship. So basically, what the Honorable High Court has said, there were vehement arguments, Your Lordship, whereby.
Okay, I got my point.
Yeah.
You can now start.
Yeah.
You can proceed as per your convenience.
So Lordship, the impugned order here is page 1 of the compilation. So I'll take you to the impugned order. Very briefly, I'll want to lay out what exactly I'm trying to establish. Lordship, the impugned order gives me certain rights in terms of expectation, in terms of crystallization as per the submissions made by the state. Subsequent to the order in 17, we have come up in a contempt petition now. Because by filing an RTI, we came to know nothing was happening regarding our compensation. The defense that the state has taken happens to be all the items, documents, arguments which they had taken in PIL 101 to establish initially, as well as on affidavit, the fact that the compensation was for new alignment and not old alignment. An argument which they surrendered. The 2-3 main arguments which perhaps convinced them to surrender is one, for the Nazir Ahmad principle, you can't do what is against the statute. You have to do things as per the law prescribed. So you have to first have a acquisition order, then only you can do the rest or give the money to anybody for that land acquisition. So that portion of the land was not acquired. Clearly as per the notifications which were published in the newspaper and which were notified by the state. Next, Your Lordship, they also argued, they gave the line diagram which I just showed you, which clearly says proposed alignment for the short one. They also gave a list of persons who would be compensated, a list of compensated, etc. All this was argued at length. The point I am making is, this matter has been adjudicated upon. They cannot regurgitate it again and again and again as they are doing, third or fourth time. So that is one part of my case, that is standing it on a higher pedestal of law, not just facts. So as per law, promissory estoppel, res judicata, squarely apply to this matter. Also, there is the question of doctrine of merger. My
Promissory estoppel, okay, res judicata because of 101.
There is res judicata in 101 and then again in 154 and 260, and also the ADC, when he restored our LPCs, was acting in a quasi-judicial authority, and that order of restoration gets merged with the series of judgments. Because that was done at the instance of the court under a court order, and it was recognized by the Honorable Court in its order of 17, writ petition 17. Not only that, the state itself conducted a survey on the land, found us to be the owners, made a list as per the order of 154-260. That order specified that at the time you make a proper survey and make a list. The order of 17 only talked about, because they had already submitted, the only matter, residual fact left when the order of 17 was finally pronounced was, what I argued was, Your Lordship, the acquisition is under Act of 2013. The compensation is being shown under earlier computational values. So the same as 2013, whatever it is, we didn't know the thing, that should be computed. Subsequently, Your Lordship, they computed it. That computation letter was received by us through an RTI also, and they sent it in a comprehensive letter to the ministry, Morth basically, asking them to arrange the funds effectively. I'll take you to that document. And Morth said, listen, we have already paid you. Even if by mistake, if you have paid, then it is the state's responsibility. We have already paid whatever compensation. So what North is saying is, as far as we are concerned, we paid you for 311 kilometers, which included this section, whatever you have handed over to us. What the state was trying to do is tell North that under court order, you should pay this money. And that is where the thing became murky. Your Lordship, if you allow me to take you to writ petition 17 order, that is from page 125. In para 2, page 1, page 3, para 2, page 3. Lordship, I'm sorry, I got hidden under one of this. I apologize, Lordship. Actually, they had not received their copy of the compilation. So, Your Lordship, the Honorable Judge observes the petitioners are landowners in different villages. And he goes on to discuss towards the last line of para 2, as appropriate acquisition proceeding was not initiated, the petitioner preferred this writ petition. In this writ petition, an earlier order dated so-and-so was passed wherein the aforesaid aspect was recorded. This is the order in which he asked for Zirat to be done. It was also recorded that one of the reasons in the delay of the land proceeding that there was a change in the alignment. Para 3, Your Lordship. Be that as it may, in the earlier order 2117, it was directed in the interim that the responsible would immediately make a survey. Then proceeding for the next line, in the aforesaid situation, an affidavit in opposition has been filed on behalf of R7, being the extra assistant commissioner in the office of Deputy Commissioner, East Command District, SEPA, wherein para 10, it has been stated that draft notification for acquisition of land has been forwarded to the Secretary Land Management, dated 19/8/2016, what I showed you also. In the aforesaid premises, we have arrived at a situation where the state authorities have initiated the process for land acquisition and the matter be brought to an end. But in Annexure 3, Your Lordship, is on page . It's basically a table on page 83, Your Lordship. Here in compilation on page 83 is the Annexure 3. Page 83. This is the table, Your Lordship, submitted by the authorities, giving our names. Your Lordship, you had asked the second name. One was Rojo Natung, the other was Lagong Natung. Lagong Natung. So, Your Lordship, the names of all the petitioners, when they did the survey, they have determined whose property. Normally, the survey is done, you determine whose property it is, from which chainage to which chainage, what is the compensation, and for the things attached to earth, for plants, etc., and for the land itself, which category of land is. So, based on that, this compensation report was made. This is part of their affidavit in writ petition 17. Based on this, the Honorable Judge has said, noticing that the column number F, Your Lordship, clearly says, column F, it talks of compensation on a notification of 2011. Column F.
Okay.
Right, Your
That
Lordship?
is why the Honorable
Yes.
Coordinate bench
Yes.
held that
Yes, Your Lordship.
it should be 2000.
It should be the new act. And they have done that also. Be that as may, the process of Your Lordship, as His Lordship goes on to say that even had they made the notification, since the land was not taken, in any case, 2013 Act will be applicable. That's the purport of para 6. As agreed to the, now, in the end, Your Lordship, logical and following the procedure, the right to fair comment, the amount will be something. So his lordship I was present in court, was inclined to give a date of a month or so. But then the state said that, it will take time to arrange funds and all. And so his lordship said, okay, financial year ending. And he has noted as agreed by the state respondents. They specifically asked for this and he accommodated them. The said proceeding we brought to its end within 31/3/18, meaning thereby within the financial year 17/18.
So we are now sure that there was a notification under section 11 in 16.
Yes.
Survey done.
Yes, and in 17, that notification also advertised your lordship. The same notification, which was in 16, was also put on a paper advertisement in 17. Just for your information.
Fine.
So
now, where is the next step under 21?
Under
21.
Yes, your lordship. The next step, your lordship, as per this order, was nothing. We were, by nothing I mean, we received nothing, so we filed an RTI. In the RTI, we were told that a document has been prepared, which I am taking you to.
So with regard to the section 11 notification, nothing proceeded.
No, they did a survey, your lordship.
Survey, but thereafter nothing proceeded.
No, we didn't get anything. But what did proceed, I am trying to tell your lordship, that after this order, that it should be on the new rates, they prepared a notification of the new rates and sent it to the government and to MORTH. That this is some, earlier was 21 crores, now it came to 33 crores. And they sent it to MORTH. MORTH replied that whatever it is your headache, not mine.
Have they at any point of time thereafter withdrawn that 11 notification?
No, your lordship. None of the orders have been appealed. No notification has been withdrawn. The petitions, the order of 17 was, a review was filed, but then withdrawn after extensive hearings.
Yes, what do you want to show me?
Yeah, just lordship.
Can I just ask Mr. Tapin one thing?
Yes, yes.
Mr. Tapin, you paid, you did not pay, that will come. But you yourself issued a notification under section 11 in 2016. Thereafter, you carried out a survey. Then this court's order that therein it was under the Balipara Act. That 1894 compensation was determined under Balipara. Under your 2011 notification, which is Balipara and 1894. Now, what happened to that process?
Comes to a logical analysis as per the direction given by this order. Direction given in the constitution in the 17th.
17, the court said, now you recalculate the thing in terms of 2030.
Lordship.
To a logical conclusion. And accordingly, also, when this
Logical conclusion would be in terms of that survey.
Then we filed a review petition before
Dismissed.
So that was part of it. Then this fact was brought in.
Forget it.
Lordship,
That
may I
is
answer?
today we will not go into it.
Because it's relevant. The query the lawsuit is asking about it. Here lawsuit, we said lawsuit, these facts has been found after the judgment has been placed before the authority. This amount was already paid near the judgment. So with this new fact lawsuit, we filed review petition.
Okay, I got it. I got it.
And the honorable court said, as an observation lawsuit, though it's not reflected in the order lawsuit. You have not been directed to pay, but to reach to a logical conclusion.
Your Lordship, that was never said, Your Lordship.
Mr. Kashyap.
Yeah.
Then Lordship,
Mr. Tapin was also not there. So-
I was there, Your Lordship.
So he is being briefed, so he can say only that. Mr. Tapin,
so accordingly,
Mr. Tapin, I got it. That Mr. Kashyap has received all compensation. And this was something done by your deputy commissioners, maybe there, maybe. But the thing is, if that is the conclusion you have reached, that they were already paid the money for this new alignment, 15 kilometers, then what prevented you from withdrawing that 2016 LA notification?
the PN 101. Here also so far this confirmations as to the new alignment.
Mr. Tapin, why are you going back to 2101? We are in 2016 now. This court is now in 2016. There is a notification notified, as Mr. Kashyap has said, in 2017. Pursuant to that, direction passed by the court, survey done. Now, direction 2013 Act to be applied. You file, then you get materials. Oh, we have paid. So, why have you not withdrawn that 2016 notification on the ground that this was erroneously issued? Or why have you not gone up on appeal against 2017 when your review was rejected?
Review was withdrawn.
Withdrawn. Okay, withdrawn. Nothing. So why did you go up on appeal?
So far the query date was.
Now, can we go beyond 2017, 17 of 2017?
Our project is what our project is. The notification is there in one of those is the actual question. If there is wrong, illegal, though it was issued, knowing the actual question, so fraud has been committed. If that notification is even issued, there cannot be legally validated. Outcome from that point.
No, see, before this court, that notification was considered and this court had passed an interim direction. Then it went up to a finality, then you come up, right?
Lord,
Hmm.
may I seek an indulgence, Your
Hmm,
Lordship?
hmm.
Lordship, kindly come to page 157 of the compilation. 117, Your Lordship, 117 of the compilation. Tells the whole story and it is their document, not ours.
Okay.
Your Lordship, may I read this?
Mr. Tapin,
This is
this
2018.
notification of 19/8/2016 was issued by the Deputy Commissioner, right? Normally, page 82 of that convenience compilation. So, this is issued in the name of the governor, right? So, the deputy commissioner naturally had taken the approval of the government land matter. Where is your stand that this 19/8/2016 was issued by the deputy commissioner on his own? Because he is issuing it in the name of the governor and this has come to your notice umpteen number of times thereafter.
Secretary's instructions are on record, Your Lordship, asking him to go ahead under the,
Balipara.
no, not Balipara, under the new act, under the High Court's orders.
Forget it. That is subsequent.
No, Your
we
Lordship,
are on 1980.
Change of incumbents. So this is the no authority says. So that is there also. But I'll address all these issues. My lordship, basically my point would be lordship. The fraud reshapes everything else. And this one
No, first to come to a conclusion that it is a fraud, there also has to be some material because this has been gone through by this court once.
This case was not before a court.
Be that as it may. And that fact, the review you brought, you had to withdraw. And after 17, what is the proceeding? This is the proceeding.
this, Your Lordship, I am showing you, if you look at page 151, I'm sorry, 117, 117. page 117 of the compilation. Your Lordship, their defense here is of understand 117, Your Lordship.
Mr. Tapin, just think over what I'm trying to get from you. 170.
17, Your Lordship.
What is the other number there in that page?
141. Your Lordship, this is answering your question of what happened next. Now these are 4 or 5 pages which clearly tell the story and make it crystal clear. May I read it, Your Lordship?
Okay.
Okay. To the Additional Director General Zone, this is a letter going from Government of India and coming to the Ministry of from the Ministry of to the Ministry of Road Transport. Please find info copy of compensation estimate prepared under LARR Act 2013 for 1E segment Nichupu to Hoj project as per judgment passed by Guwahati High Court. The Honorable High Court has directed the land acquisition proceeding to be completed by 31/3/18. Next para. The DC has informed that the land for City to Pakra 15 was handed over to Ministry on 29/6/13. However, this land was as per original award of contract, that is not along VRO, that is along VRO road and not along new alignment. Now DC SEPA has submitted the compensation estimate as per new alignment, Sede to Pakro via so and this under LARR account act at 33.81 crores. In this regard, comments of state and are invited. Now, next page, Your Lordship, page 119.
Who is this authority?
This, Your Lordship, is the Executive Engineer Regional Office of the Government of India, writing to his boss in Delhi.
Has Government of India filed any affidavit here?
No.
Are they a party here?
No.
They are not a party.
They are not a party.
So
they were not a party in any of these because, Your Lordship, the very.
Mr. Kashyap,
yeah.
How long will you be coming to this court? This has to be taken to its logical conclusion.
It has to reach a logical conclusion earlier the better.
Now we are all doing this. We are saying something, we are relying on documents of the government.
No,
why is the Government of India not made a party?
I'm telling you, I told you the problem really, sir. We also didn't know it. We realized it later when we saw their replies. The problem is we have been made a coin on the carom board.
I know that. But
because
now,
money is not there. That is the problem.
Now, as far as subject to what Mr. Tapin would say finally, we have been now trying to boil down the matter to a logical thing. And 17 is there.
Lordship, 2017 December note.
And
that
these
tells
two letters,
everything clearly. Lordship,
these 2 letters would do it. But the thing is...
No, Lordship, if you say to come to page 119, you will get more clarity, Your Lordship, and it crystallizes further.
119. What is the other number?
152.
After that thing you were showing.
That's right. After that thing.
152, yes.
Yes. Now, Your Lordship, this is a note prepared by the DC. Not a DC.
This thing is very doubtful here.
Your Lordship, this document is clearly stating the sequence of events. And this document has been is attached in their affidavits.
I know.
I have got it from their affidavit.
I know that.
What
Tapin has also agreed to that initially they did not know. Subsequently, when they came, that's why I asked him. Your review was dismissed. Why don't you go up for appeal?
Your Lordship, if you allow me, my interpretation, I can tell you why they didn't go. Is because they tried desperately
Mr. Kashyap,
yeah.
Let us not proceed. I think the Government of India should be made a party here. Should be made a party. No, forget it. Here. In 17 it was there.
Yeah,
but here it is not there.
It is not.
It's not there. It's not there because it's their land. They have constructing. So we would like to have, and those documents are there. Let them say that, no, we have paid for the whole alignment, not the,
But
that is
your
the end of
lordship-
the matter.
Your lordship, why we didn't make them a party is because it is clearly said in their documents
No, we
that
are.
the state is
No,
responsible.
no, why? Let them come up and say that before us. Call Mr. Thakur.
So lordship, I would only humbly request, we'll make them a party. Hopefully this doesn't become a, sorry, another very long.
No. I want them as a party today only by permitting you. By hand, I'm asking you
Yeah,
to make it.
I'm.
Because Mr.
I'm in your,
Otherwise, see, now we have
outstand.
boiled down. Now to come to a logical conclusion, we have to have them before us. Because it's between you and.
Lordship, the problem of money is between them and the government.
That's what I said.
And the government, they will say, we have given the money.
Now
What
that
the state
documents
should
that
have
you
done.
have shown me,
Right. No?
that 412,
Yes.
it's their officer writing. What is the conclusion? What happened to these?
Your lordship, then the secretary has also written.
No. This page 117,
Yes,
oblique
yes.
141,
Yes, yes.
116, 151.
Yeah.
Their officer, this is your case.
Yeah.
Page 141 is your case. This letter of the ministry,
I agree.
this is your case.
Yeah, but we
What
have taken
happened?
it from their documents. This is our case, your lordship.
This is your case.
Yes.
Now,
The point,
what happened? What was the reply of the ministry of?
your lordship, I'm telling you, the ministry told the state.
Where? Where is
Oh,
that?
I'll show you that. Show you. Lordship, before that, there is another document which is in sequence of the same line of communication, page 112. Page 112. In fact, that note.
Okay, any CGC, any other central government council?
Lordship, page 112. This is the communication. This is again part of the what happened next. And the note you just saw
Is in terms of
is,
this.
is
It refers to
it is an annexure to this.
It refers to the estimate, LA estimate of.
Yes.
No, show me where is that response of the government?
Now this has gone to the Ministry of Road Transport, right? Now, if we see the secretary's affidavit in reply. Sir, your lordship, Government of India is a party. I am not.
Where?
Secretary, Government of India is very much a party, your lordship.
Yeah.
Yes.
Where?
Your lordship, kindly see. See
359.
R1 counter.
No.
In 359.
359.
In contempt petition 15.
Contempt we are not.
Contempt mein is a party, your lordship.
Okay, contempt, because they were there respondent in that. I want it in the repetition.
Let me just double check, your lordship. Because,
no, I'm also checking.
so, lordship, what happened traveling to here? Let me just double check, your lordship, before.
No, let us come to that.
Because in contempt, he was definitely a party. I remember that. 359. Let me see.
No, contempt because.
No, they are in contempt, they are party.
But-
But in 359, your lordship, they have cancelled our LPCs. That is the only thing. So the central government is not involved. Our LPCs have been cancelled by the state.
So you are not claiming anything against any
No,
money?
your lordship, we are just claiming restoration of our LPCs there.
So
But in
359
contempt, we are saying that the matter has not, we have not got our funds. The order of 17 of 2017 has not been complied with. There
Okay,
the state of
Just let me have a look at your prayer in 359.
359, your lordship. It is on page
14 and 15.
14
That
and
is
15.
LPC.
Yes, this is only about LPC, your
LPC.
lordship.
Now
So we
321.
don't, 321 is a strange order, your lordship. He has cancelled our LPCs, shot us, we are dead. And then he says, "You can't be-"
Here there is a prayer
yes,
for compensation of land acquired as per new alignment by.
in 321,
What?
your lordship, what has happened is, he has made, after cancelling our LPCs in 359, the DC says that there will be no further compensation paid in this. I mean, where is the question of compensation when there is, my LPC is also cancelled?
I got it.
So there is no
But
question.
once we set aside that,
Yeah,
then the question would come, say we set aside both your
yeah.
cancellation of LPCs, 17/5/2019, then the issue would be payment of compensation.
Your lordship, that is covered by the contempt petition also.
The
Because contempt
contempt
petition
is in violation
in
of.
violation of 17.
So we,
And if 17
that we will only look into whether 17 has been
violated.
violated or
So
not.
if it is, my main case is that 17 has been violated.
But here,
Here
Mr.
also,
Mr. Kashyap, we'll have to go a step further.
So
Maybe
you-
the court at, when it was
I
accepted
see,
in
I see the
17,
merit of what your lordship is suggesting.
it's not to that court did not have the
So
access
your
to that.
lordship, I may be allowed to include Secretary
Mott,
Mott as a party in 321.
321, do it. That'll change the color of everything. That
So-
everything will be clear then.
Yeah. So your lordship, can you help me with the timetable on this? I can do it very quickly. I mean,
If you can do it, I should be here.
my
By
colleague will be here even on Monday. So he is local.
you can file it Monday, Tuesday. Monday would be a little bit tied up. Tuesday would be better.
Okay.
You have that application, I'll immediately allow it.
Okay. And
Mr. Kato will be here, I'll personally,
limited time may be given. Your lordship,
not more than second week of January.
Okay.
Let
And
that
then
come.
your lordship, since my other problem, your lordship, is I have argued this matter 3 times.
I know that. Now at least I have understood.
So I've
what you're
become an
trying
expert.
to-
I've become an expert on this.
No, I've been
So
trying
would
to.
it be possible for you to continue the hearing as well?
Let us see.
And we could file an application with the chief if
No.
how does that work? I don't know here.
It doesn't work that way.
Oh my God.
It doesn't work that way, and it's not permissible also.
Okay. So what do we do?
So what we do is, let me see my next roster. I'll get to know. So maybe I'll be here in February.
Okay.
February. So if this notice period is over, we can have the matter. I can continue with that.
Much obliged, your lord.
Otherwise,
Kindly don't release it, your lordship, because several judges have released the matter after a
no,
month.
I'm not releasing it. Not
Much
releasing it.
obliged.
If it is released by its own, it will be. Otherwise, I'm not releasing it.
Maybe you could pass an order that will be heard on February. Right now.
No, that would be problematic because I don't know my roster. If I'm in Guwahati, it's very difficult. Very difficult. We are only on that. We have only
Your
on
lordship,
that.
but the fee may get divided. That's my worry. I'm sorry, your lordship, I shouldn't talk like this.
It's nothing like that. Now that thing has boiled down. Let us see. Have it on 18th. 18th.
Okay.
18th, before 18th, you bring that on record. I'll fix it on 18th. And on 18th, let me see when we can fix it. I'll continue the part order. 18th of this month. For that impleading application.
Implement application.
When this application is filed, automatically the notice is listed.
Okay.
When I is filed, it will be listed. When the case is filed,
Anyway.
Your lordship, today's order may show that it will be filed before 18th.
The hearing of the matter was continued today. During the course of submissions made by Mr. Kashyap and also the clarifications which were received from Mr. S. Tapin, it was found that the Ministry, Government of India, Union of India Ministry of Road Transport and Highway is a necessary party to the dispute involved in the present proceedings. However, it was found that the they have found that they said that the said authority was not implemented as a respondent in the present in either W
321. Yeah,
and
321.
or 359. 321 2019 and or 359 2018. So, in view of the above position, the learned counsel for the parties have agreed that the learned counsel for the learned counsel for the petitioner has submitted that he would file an application for implementing the Ministry of Road Transport and Highway as a party respondent in the said matter, and accordingly submits that the matter be taken up on 18th. 18th. Full stop. No. December. 18 December. Full stop. Full stop. Matter to be listed on 18 December for as a parted item.
Suppose say if I expire on 16 also, the matter will be listed also. It's a matter of law.
That's why I fixed it on 18th.
Even if it's also. Because if when I expire, the registry automatically used to this.
Let them come. Very good. Mr.
Just
Kashyap
let
is not required. He will be there. We'll pass the order. No, good. That's a good thing. That's a good thing. It's not like God, you file an IA, you wait for ages to get that thing listed. It's better here.
Your Lordship, Supreme Court is worse. Supreme Court, you can forget whether it will come. I have a murder matter, Your Lordship, which.
No, here that it's very smooth. Registry is very good.
No, it's very good. Your Lordship, I find the Guwahati High Court to be one of the best courts in the country. And that is why you have been producing so many illustrious judges also. One after another.
Those are our ideals.
Yeah.
They are our stars.
I think Your Lordship, the culture which Calcutta High Court has and has lost has been inherited by the Guwahati High Court.
No, it's a self-developed culture here. This is something which
But
we...
in Calcutta, you don't have that.
I don't know that. I've never been to Calcutta. But in Guwahati High Court, in the bar, it's very... It's a culture which is going on for a long time.
Your Lordship, I enjoy my work.
I have seen it where the seniors have a sort of a control over the junior incumbents, and the junior
And they
incumbents
nurture
have
them.
a respect.
They are nurturing them.
Have a respect. So till that culture continues, I think we have
It
a
will,
very
Your
good,
Lordship.
we have a very good
New
future.
judges are also coming up.
We have a very good future. Thank you.
Much obliged.